Small network issue. Just confirm me. Is voice audible? Okay, fine. So first of all, I welcome you all to this last minute handwritten notes marathon. In this marathon, I'll cover all the chapters using handwritten notes. So on the screen you can see chapter number 2, incorporation of companies and matters incidental thereto. Clear? Chalo, let's begin the marathon. If you have any doubt, I'll give you a break time. So in that break time, I'll answer you personally. Clear? Fine. Let's begin the marathon of handwritten notes. Coming to chapter number 2, incorporation of company and matters incidental thereto. This chapter is having a weightage of 5 to 7 marks in your examination. Starting with section 3, every company should be formed for lawful purpose only. Once you select a company type of organization for business or charitable purpose, you will be given 3 options: OPC, private limited, public limited. For OPC, 1 member is enough. For private limited, minimum 2 members required. For public limited company, minimum 7 members are required. And once you select the option, again you will be given 3 options. You can select limited by shares, limited by guarantee, unlimited company. Clear? Now this minimum number of members, 1, 2, 7, this limit we need to satisfy not only at the time of incorporation but also after incorporation. Suppose if this one person die, no problem, nominee become member of OPC. Coming to private limited company or coming to public limited company, if number of members fall below the statutory limit, then lawmaker is giving a time limit of 6 months. Within 6 months from the date of reduction, yes, the number should be increased to statutory limit. If not, then the members who are aware of the fact that company is carrying business operations with reduced number of members, not all the members, but the members who are aware of the fact that the company is carrying business operations with reduced number of members, their liability is converted. Their liability is no more a limited liability. They're liable for all the liabilities of the company jointly and severally for the debts contracted by the company after expiry of 6 months. For example, as on date of reduction, total liabilities of the company is 60 crores. As on date of reduction, expiry of 6 months, debts increased to 90 crores. And after some time, when you see company total debts, it went up to 105 crores. Now, whatever debts incurred during this period, which period after expiry of 6 months, amounting rupees 15 crores. For this amount, members are liable jointly and severally. There is no limit. Coming to this 90 crores, company is liable, whereas debts incurred after expiry of 6 months, members are jointly and severally liable. All members are members aware of the fact that company is carrying business operations with reduced number of members. Only those members will get punishment. What punishment? Joint and several liability. That is all about section 3 and section 3A. Next one. Section 7, incorporation of company. So coming to incorporation of company, first promoters will prepare documents and will submit these documents to ROC. Which ROC? ROC having jurisdiction over your proposed company's registered office. So in which state you want to establish registered office, that state ROC you have to file the documents. Sir, what are the documents, sir? MOA, AOA, signed MOA, signed AOA, declaration of compliance that we have complied all the provisions of Companies Act and rules made thereunder. Yes, the declaration should be signed by a professional, namely CA or CME or CS or advocate in practice, and director, manager, secretary involved in the incorporation. Next, a declaration by the subscriber and directors stating that last 5 years we have not been convicted for any offense. We have not found guilty of fraud. Here offense related to promotion, offenses involved in the promotion, incorporation, management of the company. So here date of committing crime is not a matter. When that crime was proved, when he was convicted, from the date of conviction onwards, next 5 years ban period. Next 5 years, he cannot become subscriber, he cannot become a director of any other company. And he was not found guilty of the fraud during the last 5 years. Next, for the proposed company, what are all the documents, they are filing with ROC? They are complete and correct. Next. And all these documents, once you file, next one, details of the directors and subscribers. So details means, sir, what comes in the details, sir? If individual is the subscriber, or if subscriber is an individual, name, photograph, father, mother name, nationality, proof, ID proof, date of birth, place of birth, educational qualification, PAN, email, mobile number, address proof. Simply KYC documents plus address proof. If subscriber is a body corporate, then you have to furnish this information: name of the body corporate, SIN or GLN or an email ID, registered office address, place of business. If body corporate is a company, then board resolution certified copy. If body corporate is LLP, then partners resolution certified copy. And if a foreign company, then certificate of incorporation details and registered address. So these particulars to be furnished. And next, directors. Upon incorporation, who will take the position of directors? They need to give written consent to the company. So they had no objection to act as directors of the company, written consent of the directors, and interest of the directors in other business entities. See, to identify related party transactions, first we need to know who are the related parties. For that, we are asking directors to furnish interested business entities details. Next, address for temporary correspondence. Upon incorporation, company should have a registered office. Until then, a temporary address for correspondence. So file this information with ROC having jurisdiction over your proposed registered office or proposed company's incorporation. Finally, ROC issues certificate of incorporation. Once company is incorporated, yes, all the documents you filed with ROC for incorporation, you need to preserve them at registered office. Sir, how long, sir? Till liquidation. Till liquidation. So these are the documents we need to file for incorporation of the company. Subscriber details already over. Coming to signing of MOA, AOA. In one attempt, this particular point was tested for 6 marks. So coming to signing of MOA, AOA, subscriber signing MOA, AOA alone is not enough. He need to add his name, address, description, occupation, and along that one witness should sign it. One witness should authorize it. Yes, this particular fellow is a real person. He is in existence. He is not a fictitious person. Like that, witness will sign it. Suppose if subscriber is illiterate subscriber, then ask him to affix thumb, and it should be the same should be written and signed by the witness. So affixing thumb mark is important. Next one, if body corporate is subscriber, then who will sign MOA, sir? Authorized director or authorized officer or authorized employee will sign on behalf of the body corporate. Now coming to the foreign national subscriber. Here you need to check whether he is a non-resident or resident. Suppose foreign national subscriber came to India. For that, he need a business visa. Now ask him to submit business visa as a proof, and then he will sign MOA and AOA. No, sir, he is a non-resident, sir. Then his document should be notarized by notary public. Or if he belongs to a country which is a member of Hague Apostille Convention, then the document must be apostilled. No, sir, he is not a part of, his country is not a part of Hague Apostille Convention. Then ask him to get his documents authenticated by diplomatic or consular officer. So these documents, foreign national subscriber has to submit. Next, during incorporation, if the promoters file any false information or if they suppress any material facts, then what would be the consequences? We need to check whether company was incorporated or not incorporated. Suppose ROC identified these mistakes much before issuing incorporation certificate, then the persons who are involved in this incorporation will get punishment under section 447. Sir, suppose company was already incorporated, sir. Later, ROC came to know that company was incorporated by furnishing false information or suppression of material facts. Then the defaulting person will get punishment under section 447. And for company also there is a punishment. NCLT may order changes in MOA, AOA, and NCLT may convert members limited liability into unlimited liability. or NCLT may order for removal of the name from the register, or NCLT may order for winding up of the company, or such other orders as NCLT thinks fit. But before passing any order, NCLT will give one opportunity of being heard, and NCLT will consider all the transactions entered into by the company during the period, after incorporation, before NCLT order. All the transaction made by the company during this period will be considered by NCLT. So that is a punishment to the company by NCLT. Defaulting person gets section 447 punishment, whereas for company, any of these 5 orders may be passed. Next, so section 7 over. Next one, section 3 only, one person company. Here in one person company, there are some conditions on member nominee company. So for member and nominee, same conditions ma. What are the conditions? He or she should be citizen of India. Next, natural person. And coming to period of stay, at least 120 days in the preceding financial year. This is no more a condition. Even a non-resident can become member of OPC. Even a non-resident can become nominee of OPC. Earlier this condition is there. Right now this is not a condition. You see the point carefully. Resident or otherwise. Then what is this 120 days? Whether he is resident or not, to check it, 120 days criteria was mentioned. So right now only 2 conditions are there. Condition number 1, citizen of India. Condition number 2, natural person. Max to max, he can become member only in one OPC. Max to max, he can become nominee in one OPC only. Now coming to the company is prohibited from carrying these 3 activities. Section 80 activities not allowed. NBFC activities not allowed. Investment in body corporate activities not allowed. Clear? Next. So coming to the nominee. So before naming someone as nominee, you have to take written consent from the nominee. In case of vacancy, sir, why vacancy comes? Suppose nominee withdrawn consent, or nominee, member removed nominee, or member died, nominee is becoming member. In all these cases, what is the date of vacancy? From the date of vacancy, within 15 days, appoint a new nominee. And within 30 days, communicate the same with ROC. Whether nominee withdrawn his consent or member removing the nominee or nominee becoming a member, within 30 days, appointment formalities and communication with ROC should also be completed. Now coming to OPC, sir, what are the benefits an OPC is entitled to? Coming to the benefits, cash flow statement not applicable to OPC. Signing of financial statements, one director signing financial statements is enough. Annual return signing also, one director signing annual return is enough. AGM necessary or not necessary? Not necessary, because for general meeting minimum 2 members are required. In OPC minimum and maximum number of members is 1 only. AGM not necessary. Suppose in board only 1 director is there, then board meeting is also not necessary. Coming to filing of financial statements, the time limit is OPC should file financial statements with ROC within 180 days of closure of financial year. For all other companies, within 30 days of AGM, but for OPC, 180 days of closure of financial year is the time limit for filing financial statements. Handwritten notes I'll upload in Google Drive, and I'll share the link after once this marathon is over for today. Okay, don't worry, I'll share it with you. It is a free resource only. Don't worry, just concentrate. So that's all about one person company. Over. Next one, section 8, formation of company with charitable objects. Not all companies are for doing business. Not all companies are meant for carrying business operations. There will be some companies which are meant for doing some charitable activities. So now coming to section 8 company or a company with charitable objects, you can see 3 prerequisites, very, very important. A company should satisfy these 3 conditions, then only it can get a section 8 license from central government, license under section 8. So what are the 3 conditions, sir? Objectives. Its objects, MOA object clause should contain social welfare, art, science, environment, research, charity, sports as objects. So simply charitable objects. Second one, dividends, strict prohibition. Dividends are strictly prohibited. These people are not doing business. Dividends are declared out of profits. These people are not doing business operations. Clear? So dividends not allowed. Then what to do with surplus, sir? Apply surplus for promoting objects of the company. And section 8 company, being a company, it can enjoy all the privileges as a limited company. Now benefits to section 8 company: for a general meeting 21 clear days notice is required, but section 8 company 14 clear days notice is enough. And minimum number of directors, nomination remuneration committee, shareholder relationship committee, such committees are not required in case of one person company. Even a partnership firm can become a member. So this point can be tested ma. Even a partnership firm can become member of section 8 company. Generally in company, to become a member, the person should be either natural person or an artificial person. Partnership firm can never become a member of a company. But in section 8 company, partnership firm can become member directly. Next one, usage of words private, limited, limited. Required or not required? Not required with respect to section 8 companies. Next one, procedure. First, apply for registration. Just now we have seen section 7, incorporation. Follow this procedure. Next, supporting documents, MOA, AOA, estimates of income and expenditure for the next 3 years. So how you are going to procure money and how you are going to spend that money, how you are going to mobilize money and how you are going to spend the money. Declaration of complaints by the professional. As I told you, CA or CMA or CS or advocate in practice will sign this declaration. Yes, everything is as per Companies Act and rules made thereunder. Now central government will grant license to the company. Company will file license with ROC. That's it. Company now onwards, it's a section 8 company or a licensed company. Okay na? Next one, revocation of license. License will be revoked in the following cases. First, contravention of section 8. Suppose there is a distribution of dividends. Company objects has been changed from charity to business, or license conditions has been contravened, or affairs have been conducted in a fraudulent way. For converting black money into white money, you incorporated section 8 company, for example. So in that case, after giving an opportunity of being heard, NCLT will pass an order. Authority will pass an order. Central government will pass an order. Either it may order for winding up or it may order for amalgamation with similar section 8 company. Similar company means similar section 8 company. If authority decided to wind up the company, then once after selling all the assets, and after settlement of all liabilities, whatever surplus amount is there, that amount will be transferred to insolvency and bankruptcy fund. Surplus amount will be transferred to insolvency and bankruptcy fund. Next one, in this process, if it has been identified that company has been incorporated for carrying fraudulent activities, then the person who is involved in that fraudulent affairs, so that fellow will get a punishment under section 447. Next one, and for company, the default, in case of default by company, the punishment is 10 lakhs to 1 crore. For officer in default, the punishment is 25,000 to 25 lakhs. If any officer is involved in fraudulent affairs, then punishment is 447. Fraudulent affairs, one simple example, incorporating section 8 company for converting black money into white money by way of making donations. So creating some fictitious records, creating some fictitious people, and you're recording like donations from the people. Like that, if you are converting black into white using section 8 company, that means a fraudulent affairs only. OID, officer in default, gets punishment under section 447. As I told you, before passing any order, yes, one opportunity of being heard will be given and it will consider all the transactions that company made during this period. Next one. Yes ma, for September 26 also I'll do expected exceptional topics marathon. Don't worry, it will be for 2.5-3 hours, similar to May attempt only. I'll do it, nothing to worry. Next, provision for conversion of section 8 company. Section 8 company into other company ma. Charitable company into business oriented companies. So for that, pass a special resolution. This special resolution is not for conversion. This special resolution is for making an application. So company has to file an application with a regional director. Along with application, these are the attachments. I hope screen is visible, right? Special resolution, certified copy of special resolution, meeting notice and explanatory statement, and Notice should be served to following 4 people: Chief Commissioner of Income Tax, Income Tax Officer, Charity Commissioner, Chief Secretary of the State. And whether you served a notice or not, attach a proof. And these people will have a timeline of 60 days for making any objections. These people can make representation within 60 days of receiving the notice. Once done, regional director will approve the application. Once regional director approve the application, file it with ROC. And you need to publish the notice. You need to publish the notice in 2 newspapers: vernacular newspaper, English newspaper, and you have to publish it on the website. Sir, why these requirements? Very simple. Many people thinking you as a Section 8 company have made donations in the past. So now you need to stop them. They should not donate to you because you are no more a Section 8 company. So that's why this much publication you will observe. Compliance with filings, all the financial statements, annual returns, and all the statutory filings, there should be strict compliance. That means you have to file latest financial, up to date, all the financial statements, annual returns should be filed. Now here there arises a tricky point. The tricky point is previous financial year closure date and date of application with regional director. If the time gap between these two is less than 3 months, no problem, file latest financial statements with RD, enough. But if the application date is more than 3 months from previous financial year closure date, that means the time gap between previous financial closure date and date of application is more than 3 months. Now for this duration also, for this period also, prepare financial statements, get them certified, and it should not be older than 30 days. It should not be older than 30 days. Also file them, because we should know the latest status of the company. So how much amount donations company received during this period also, we need that information. Yes, get it audited, at least limited review. At least review should be completed. Now file those latest financial statements. RD, before passing any order, RD will give one opportunity of being heard. Next one. Now once RD give approval, call for a general meeting and pass a special resolution. Sir, already I passed special resolution. No, this special resolution is for application with RD. This special resolution is for alteration of MOA, alteration of AOA. Once MOA, AOA gets altered, then company has to file it with ROC. ROC will issue fresh certificate of incorporation, adding the words private limited or limited after its name clause. And one more point here you need to remember, for alter Section 8 company, first Section 8 company, in my concept book you can see it, first Section 8 company, if you want to alter MOA, regional director permission is required. If you want to alter AOA, ROC permission is required. Clear? These 2 points also you need to remember. Altered MOA, RD approval; alter AOA, ROC approval is required. Next one, Section 9, effect of registration. From the date of incorporation, that association is a body corporate. It will have a perpetual succession character. It can acquire property, hold property, dispose property in its own name, and it can enter into contracts in its own name. It can sue debtors, it can be sued by the creditors, and all the subscribers to MOA becomes members of the company. That is the effect of incorporation, Section 9. Next, Section 4, Memorandum of Association. See, this is the fundamental document for formation of company. And in Section 4, you can see 7 subsections. First one, details in MOA. Second one, restrictions on name, reservation of name, Schedule 1, and company limited by guarantee. In case of company limited by guarantee, if association or if a company agrees to share profits with a non-member, then that clause is void. In a company limited by guarantee, without share capital, or simply in a company limited by guarantee, if directors agree to share any portion of profits with a non-member, then that clause is void. Next one, reservation of name. For a proposed company's incorporation or existing company which is planning to change its name, so for that they need to file a form for reservation of the name, reservation of the unique name. For proposed company, the name will be reserved for 20 days, and existing company, the name will be reserved for 60 days. In this application, if any irregularity was there, suppose you file an application for a name which is identical to or similar to the name of existing company, then ROC will give you 15 days time period for resubmission. Now you need to rectify that irregularity and you need to file that form once again. And coming to reservation of name, for reservation of name, if you furnish any false information, if you reserve the name by furnishing false information, whether company was incorporated or not yet incorporated. If company was not yet incorporated, the reserved name shall be cancelled and applicant will get a penalty up to 1 lakh rupees. If company was incorporated, if business transactions not yet happened, then ROC will strike up the name. If business transactions happened, ROC will file a petition with NCLT for winding up of the company. ROC requests NCLT, please, order for winding up. Or ROC will give you one more chance. The chance is, it will give you 3 months time period. Within these 3 months, you need to rectify the name by passing an ordinary resolution. So any of these powers, ROC can exercise. Next one, immediately in this object clause, object clause of MOA, in the object clause you can see the powers of the company, what company can do, what company cannot do, everything is there in MOA. Simply what to do, the things specified in MOA, do it. What not to do, the things not specified in MOA, don't do. So now coming to doctrine of ultra-vires. Ultra-vires acts are void ab initio. So, sir, what is this doctrine of ultra-vires? Company powers are limited by its MOA. As a normal person, natural person, my powers, my duties, I'll refer it to constitution. And for company, what is a constitutional document? MOA. So the powers of company get it from, company get its powers from MOA. Now the point is, if company is entering into a transaction which is beyond the powers, then we call it as ultra-vires. Ultra-vires acts are always void ab initio. Company cannot ratify ultra-vires acts. Of course, if it is ultra-vires as to AOA, can be ratified because it is not an ultra-vires to company, it is an intra-vires to the company. Ultra-vires as to MOA cannot be ratified. Neither company nor outsiders enforce ultra-vires acts. I mean, a single member with a single share can bring injunction order against the company. A single member with a single share can bring a stop order against company from entering into ultra-vires acts. Board of directors are personally liable to outsiders for ultra-vires acts. So this doctrine is to protect members' funds. Company can utilize member funds only for the specified objects in the MOA, not for anything else. So remember this point, even a whole body of members cannot ratify ultra-vires as to MOA, ultra-vires acts as to MOA. Next, coming to the capital clause, here you will see 3 components: authorized share capital, number of shares, nominal value. Authorized share capital divided into number of shares and face value of each share. Bifurcation, like classification of equity, how much, preference, how much, that is not mandatory. That is not mandatory. But how many number of shares and what is the face value, this is mandatory. Subscription clause, each and every subscriber must agree to take at least 1 share. In case of OPC, the additional clause you can see, that is a nomination clause. In the event of death of the member or incapacity to continue as a member, nominee will take the position of member. That is all about section 4. Next one, section 10, effect of MOA and AOA. MOA, AOA once registered legally bind the company and its members as if they had personally signed these documents. If you observe, Infosys was incorporated in 1981. Today I am becoming member of Infosys. Now am I bound by MOA and AOA of the company? Of course yes. Even though I didn't sign MOA AOA, because of section 10, it is a deemed provision. It's a assumption based provision. As if. That means what? Even though you didn't sign MOA AOA, the moment you become member of Infosys, you are bound by Infosys MOA and AOA. Next one. This video is permanently available. Nothing to worry. Next, section 13, alteration of MOA. Alterations. Alteration means what? Additions, substitutions, omissions. So for alteration of MOA, what type of resolution is required, Special resolution. Special resolution. Of course, for alteration of capital clause and rectification of name, OR is enough. These two cases, remember, alteration of capital clause and rectification of name, OR is enough. Next one, subsection 2, 3 talks about name change. 4, 5, 7 talks about change of state, change of registered office, ROC filings, change of objects, share of profits with an outsider is void. This is already I discussed this point with you. Next, coming to the name change. Name change. So this is a voluntary change of name. Voluntary change of name. In case of voluntary change of name, you have to check whether company is falling within these limits or not. Sorry, if company is falling within this criteria or not. If company is falling within this criteria, then name change is not allowed. So what is this criteria? Non-filings with ROC, non-ROC filings. If company is not filing financial statements, annual returns with ROC, then change of name is not allowed. Non-payments, debentures matured, deposits matured, interest on debentures, interest on deposits. If company is not paying these amounts, then also company is not allowed to change its name. Then what is the solution, sir? First rectify them, then change of name is allowed. Okay, no? Next, pass a board resolution, file RUN, reserve unique name with ROC. So here name will be reserved for 60 days. And government permission is not required for change of name in case of change in constitution. Public to private, private to public. Suppose Infosys Technologies Private Limited is a company. Now they want to convert themselves into public limited company. Infosys Private Limited to Infosys Limited. For that, this criteria is not applicable. Directly you can change because change of constitution, byproduct change of name. Addition of word private, deletion of word private. Next one. Now call for a general meeting. In general meeting, ask members to pass special resolution. Once special resolution has been passed, now alter MOA, alter AOA, file all these documents with ROC, and finally ROC will issue certificate of incorporation. Most important requirement is you need to disclose the name. You need to disclose the name, former name, that means old name, for the next 2 years. That means last 2 years if you have changed any name, then the old name shall be disclosed along with the new name. How long? So once you change the name, from that point onwards, next 2 years you have to add old name to the new name. Because company's identification is only through the name. You changing that name, how public comes to know? How public comes to know? So that's why you have to disclose old name along with the new name. How many years? Just 2 years is enough. Next one, rectification of name. Rectification of name. So here existing company, that means company was incorporated, but the name of company is identical with or resembles to the name of existing company. Let me repeat. The name of company is identical with or resembles to the name of existing company or existing registered trademark. If you see in the first case, central government orders company to change its name within 3 months. For that, just pass an ordinary resolution, file altered MOA, altered AOA with ROC. Within 15 days of changes, within 15 days of ordinary resolution, file all these documents, and ROC shall issue fresh certificate of incorporation. But coming to the trademark, here central government will not take action on its own motion. Here central government expect an application from registered trademark owner. This registered trademark owner should file an application within 3 years of incorporation of this company. When this company was incorporated using the name of registered trademark, when this company was incorporated, from the date of incorporation, or suppose sir, this company was incorporated 20 years back, right now they changed the name and the new name is similar to the name of existing trademark, sir. Now when they changed the name or when the company was incorporated, so from that event onwards, within 3 years, the registered trademark owner has to file an application with the central government. Now central government will order the company to change its name within how many months? Within same period of 3 months. For that, follow the same procedure. Ask members to pass a ordinary resolution, alter the documents, file with ROC. ROC shall issue fresh certificate of incorporation. Suppose if company commits any default, if company is not changing its name, then central government allots new name to the company. It's like a new naming ceremony. Okay, central government allots new name to the company. Of course, company by following section 13 alteration of MOA, by following section 13 alteration of MOA provisions, if they want they can change the name. If they didn't like If they are not liking the name given by the central government, of course company can change its name, but this time you have to follow section 13. That means a special resolution to be passed. Clear? Next one, change of registered office. Change of registered office, you can see for the time being 4 cases within the same city, change in city but no change in state, no change in ROC, change in ROC. So change in ROC happens only in 2 states, Tamil Nadu, Maharashtra. Next, change in the state. So total 4 cases are there. Just remember the equations. Case 1, board resolution filing with ROC is enough. Pass a board resolution and then communicate the latest address, communicate the new address with ROC. Case 2, that means change in city, no change in ROC, no change in state. Here special resolution you need to add, board resolution plus special resolution plus ROC filing. And case 3, here I am shifting my registered office from Chennai to Coimbatore, Mumbai to Pune. In that case, you know, in addition to special resolution, you have to take permission from regional director. So regional director, here I have mentioned the time limits also, ma. You know, situation 3, if you see, once you file an application with RD, RD will dispose that application within 30 days. RD, either RD may approve it or RD may reject it, but it will happen within just 30 days of application. And once RD approves it, communicate with ROC within 60 days of RD order. ROC shall issue certificate within 30 days of filing RD order. Now file INC 22 with a new ROC. With a new ROC after shifting to new address, that too within 30 days after shifting to new address. Next one, case 4. Case 4. What is the case 4? Change in state. Change in state. In case of change in state, board resolution, special resolution, creditors approval also required this time. Creditors approval also required this time. And regional director approval. Of course, here you can see central government approval, CG approval, but power already delegated to RD, and ROC filings. Here with ROC, you can see a copy of altered MOA. And these documents we need to file with a regional director also. You know, MOA with proposed changes, altered MOA with proposed changes. Meetings minutes, board resolution, special resolution copies, list of creditors to get consent from them, and acknowledged copy of service of notice to ROC and Chief Secretary of the State, and advertisement which should not be older than 30 days. Now once after filing all these documents, you know, RD will take 60 days. Concentrate on the class. RD will take 60 days. Regional director will take 60 days to process the application, and once RD approves it, file it with a regional, file it with ROC within 30 days of RD order. Next one. Yeah. Once after filing with ROC, ROC shall issue a fresh certificate within 30 days of filing with ROC, and after shifting to new state, after shifting to new premises, within 30 days after shifting to new premises, file INC 22 with ROC. So these are the equations and these are the timelines. Just go through it. So this is all about alteration of change of registered office. In all these 4 cases, you have to remember this one, change in state. In change in state, you can see there will be change in MOA. First 3 cases, there will be no changes in MOA because company is in same state where it was incorporated previously. The company was changing its address within that state. So in the first 3 cases, no need to change MOA, but in the last case, MOA changes, MOA gets changed. Next one. Change of objects. For alteration of objects, you need to get special resolution from the members, and the members who cast vote against to the change of object clause, simply dissenting shareholders. To the dissenting shareholders, promoters or controlling shareholders should give an exit offer, then alter MOA, file it with ROC within 30 days of SR. ROC shall issue a certificate within 30 days of filing. So that is all about change of objects. Next one, next alteration of AOA. Alteration of AOA. So for alteration of AOA, a special resolution is required, and filing with ROC 15 days. For MOA we have seen 30 days, and for rectification of name we have seen 15 days. Okay, but coming to alteration of AOA, within 15 days of alteration, file it with ROC. Altered AOA will have a same effect of original AOA. And even alteration includes, this is 18, alteration includes conversion, private to public, public to private. For private to public, a special resolution is required. And delete section 2 clause 68, that is the definition of private company. Delete section 2 clause 68 from the AOA. Whereas coming to public to private, a special resolution to be filed, central government approval is required because number of members should come to 200, public funds should become 0. So to check this, yes, central government will come forward and central government will verify it. Of course, power will be delegated, don't worry. So once CG approval is obtained, then add section 2 clause 68 definition to the AOA. Then company has to file an application with RD within 60 days of special resolution, and following are the attachments: altered MOA, AOA, minutes of general meeting, board resolution, special resolution copies, declaration of compliance. Very important point, because of conversion, there will be no impact on the existing obligations. Suppose a private limited company took a loan of 3 crores from SBI. After taking this loan, private limited company constitution has been changed to public company. Now is company liable to SBI or not liable? Of course, company is liable to SBI for existing debt of 3 crores. So no effect on debts, no effect on liabilities incurred before conversion. Next one. Every alteration to the MOA, to the AOA should be noted in each and every copy. Alterations to be noted, or else without such note, if any copy of MOA or AOA has been circulated, for each circulated copy, the punishment will be 1000 rupees for both company as well as officer in default. Next one, copies of documents, section 17. A member can get company documents by making a written request and upon payment of prescribed fees. Once these two conditions are satisfied, now it is the duty of companies to send the copies within 7 days of written request. In case of default, per day, company as well as officer in default, the punishment will be 1000 rupees up to 1 lakh rupees. Next one, liability of the members. In section 4, liability of the members, you can see liability of members, limited by shares, limited by guarantee. In case of limited by shares, members maximum liability is unpaid value. In case of guaranteed, companies, liability maximum guarantee amount. So now these people, present members and past members, are liable for these 3 amounts. Which 3 amounts? Deficiency. If assets are less than liabilities, then the deficiency, deficit simply, assets 60 lakhs, liabilities 1 crore. So deficit how much? 40 lakhs. Winding up cost, liquidator charges, liquidation expenses, some 10 lakhs. Suppose one member paid more amount, one member paid less amount. Now the person who paid less amount should bring a amount for settlement with another member. Suppose there are 2 members, A, B, agreed to contribute 50 lakhs each. But suppose A brought 60 lakhs. Now B should bring 10 lakhs money to settle A. For example, B brought 40 lakhs only. B brought 40 lakhs. A brought 60 lakhs. Now B should bring additional 10 lakhs for settlement with A. So that means adjustment among contributories. Clear? Sir, past member means how long we need to go? How long we need to go in past? Maximum 1 year before winding up. So when winding up is commenced, what is the date of commencement of winding up? Go back 1 year. So during this 1 year, or the transferors involved in the transfer, these people will be known as past members. See, past members will be liable only if present members are not capable to pay the amounts. Only if present member fails, then only we will go to past member. Is it clear? Everyone, just respond once. Next one. Next one, section 5, articles of association. We discussed alteration of articles, and now we are discussing articles of association. No problem, just see section 5 ma. Articles is meant for management of the company. It is a bylaw document simply. It consists regulations for management of the company. Prescribed matters you can see in articles of association. And coming to the entrenchment provisions. Sir, can a company entrench its articles of association? Yes, that entrenchment provisions can be done either at the time of formation of company or subsequent to incorporation. In case of subsequent to incorporation, for a private limited company to have entrenchment, consent of all members is required. In case of public company, special resolution alone is enough. SR is enough. Now whatever SR or consent of all members, file it with ROC within 30 days. Next one, model articles. Company can have model articles, or company can have its own articles. Company can adopt model articles, or company can have its own articles. Next one, doctrine of constructive notice. See, this doctrine is a continuation to doctrine of ultra vires. Doctrine of constructive notice. Constructive means deemed. So all the company documents which were filed with ROC are deemed to be public documents. Any person dealing with company is presumed to have knowledge of these documents, and there will be no relief for negligence, and this doctrine is for protection. This doctrine is a protection for the company. So here company is protected, outsiders will not get any right over the company. Next one, doctrine of indoor management. In doctrine of indoor management, you can see persons dealing with company are entitled to presume that all internal proceedings and requirements has been duly met. But this doctrine is not applicable in the following exceptions. If person is having knowledge of irregularity, he cannot claim benefit of indoor management. If person is negligent, indoor management privilege is not available. Forgery cases, ultra vires to MOA. So in these cases, doctrine of indoor management is not available. Under doctrine of indoor management, company was held liable and outsiders will be protected. Clear? So that means doctrine of constructive notice and doctrine of indoor management are just contrary to each other. Next one, coming to section 6. Act to override MOA, AOA, etc. Now, in case of any inconsistency between MOA, Companies Act, between AOA, Companies Act, between agreement by company, Companies Act, members resolution or board resolution with Companies Act, then Companies Act will have extra privilege. Companies Act will be referred in such cases. Inconsistency between company documents and Companies Act, the superior is Companies Act. Companies Act shall be applicable. Companies Act shall be made applicable. So any provision in MOA, AOA, agreement or resolution which is inconsistent, which is conflict to provisions of the Companies Act, then to that extent the provision becomes void. To that extent only, not entire MOA is void, only the inconsistent point will be void. Next, these time limits I already explained, got duplicated, nothing to worry. In final copy I'll remove all these things. Next one, section 14 we have seen. Section 14, alteration of AOA, we have already seen this point. So private to public, private company to public company. Special resolution, delete section 2 clause 68. Public to private, special resolution alone is not enough. CG approval also required. Then company has to file an application with RD because power already delegated to RD. So once RD gives approval, then company, yes, public company can be converted to private company. So file altered MOA, AOA and copy of minutes, copy of board resolution, special resolution, declaration of compliance. So this was also duplicated. So section 17 already completed. So in the final copy, I'll remove all these repetitions. Okay. See, today's agenda is incorporation of company, prospectus, share capital. These three topics I'm going to finish it today itself. Next one, section 12, registered office. Section 12, registered office, importance of registered office. So 3 points will tell you the importance of registered office. One is communication, investigation or inspection, jurisdiction. So communication, all the letters are addressed to registered office of the company. Inspection, investigation will happen at registered office, and all the disputes with the company, those disputes, if you want to file complaints, you have to file complaints in the court where company's registered office is situated. You know that jurisdiction, that court jurisdiction. Court jurisdiction is equal to company's registered office jurisdiction. Within 30 days of incorporation, company should have a registered office, and the same shall be communicated with ROC. For IFSC companies, it's not IPSC, it's IFSC. For IFSC companies, the time limit is not 30 days, the time limit is 60 days. Next one, outside the registered office of the company. Outside the registered office of the company and outside the each and every branch. So the name should be labeled. The name of the company should be labeled. You know, not only name, here you can see along with name, SIN, corporate identity number, registered office address, telephone number, fax number if available, email ID, website if available. This information you have to provide in the name board, and that name board should consist of 2 languages. That name should be in 2 languages, English and local language. So next one, if company is not filing with ROC about its address, its premises details, then the name of the company shall be removed from the register maintained by ROC. It's removal of name. So remember these 2 time limits. For normal companies, 30 days filing requirement. For IFSC companies, the requirement is 60 days. Next one, section 10A, commencement of business. This section is applicable to the companies with share capital, and the date of incorporation is on or after 2nd November 2018. So companies with share capital cannot start business, cannot exercise borrowing powers until 2 conditions were fulfilled. So what are those 2 conditions? So here you can see the 2 conditions are, filing INC 20A with ROC, that is declaration of paid up value. It should be done within 180 days. Next one, INC 22, it's all about verification of registered office. This should be filed within 30 days. So these 2 conditions should be satisfied. These 2 filings should be done. Then only company can start exercising borrowing powers. Company can commence its business operations. In case of default, for company, 50,000 penalty. Officer in default, each day 1,000 rupees fine up to 1 lakh rupees. 1,000 rupees penalty per day up to 1 lakh rupees. Non-filing, for delay filing, this is the penalty. In case of non-filing, ROC will inquire whether company started business operations or not. If company not yet started business operations, then it will remove the name. In case of no business transactions. In case of no business activities carried out by the company. See, this is applicable only in case of non-filing. For delay filing, this punishment is applicable. Next, section 19, subsidiary not to hold shares of holding company. So this prohibition not only limited to subsidiary company, it is also extended to subsidiary nominees also. Any allotment or transfer of shares in a holding company to its subsidiary shall be declared as void. So holding company cannot register transfer of shares in the name of subsidiary company. But there are 3 exceptions. Remember these 3 exceptions. As a legal representative, subsidiary can hold shares of holding company. As a trustee, subsidiary can hold shares of holding company. In these 2 cases, even voting is also allowed. Subsidiary can participate in general meeting of holding company. Subsidiary can exercise voting power. But if subsidiary company is a shareholder before it became subsidiary to holding company, suppose my company is holding shares of one company. I'm not a holding company to that company, I'm just holding 5%. Later that company acquired 60% of capital of mine. Now I'm the subsidiary. So what about previous holding of 5%? That means I become a shareholder of holding company before I became a subsidiary. So here you can continue to hold such shares. There is no legal provisions telling that you have to surrender the shares. No need to surrender the shares. You can continue to hold such shares, but there is no voting rights in this case. So before becoming subsidiary, you already become member of holding company. You can continue to hold those shares. No need to surrender. However, voting rights are not allowed. Voting rights are not allowed. Next one, section 20, service of documents. Any person to company or officer, or company to ROC or any member. So mode of service of documents, manual, that is post, and the other one is electronic mode. Member may request for particular mode upon payment of such fees. Coming to Nidhi companies, for Nidhi companies, service of documents is available in two modes. If a member is holding shares, face value of 1000 rupees or 1% of the paid up share capital, whichever is lower, to that member serve notice individually. Serve notice individually. Big members respect big members. Whereas others, that means holding less than 1000 rupees face value of shares or 1% of the paid up share capital, for them no need to serve notice individually. Just advertise in the local newspaper and publish it on the notice board. So that's enough. Individual notice are not required to the small members. Next, 21, authentication of documents. Authentication of documents. On behalf of company, KMP, key managerial persons, or any officer or employee authorized by board shall sign the documents. Now coming to execution of bills of exchange, company will delegate the power to a person, any person. For the delegation, letter of authority should be signed by two directors. In case company is having secretary, one director and one company secretary, enough. Suppose if company is having common seal, then along with two directors signature, affix common seal, or along with one director and one company secretary signature, affix a common seal. No common seal means common seal not required. That is all about section 22. Now here you can see the section numbers of chapter 2. First of all, remembering section numbers is not mandatory. It's up to you. If you want, you can remember the section numbers, or else not required. But if you see here, you can if you follow the story, you can easily remember the section numbers. For example, formation of company. For formation of company, two documents are very, very important: MOA, AOA. These two documents shall be prepared in accordance with Act. Then proceed with incorporation. In addition to incorporation, if you obtain license from CG, then you will be a company with charitable objects. Once company is incorporated, what is the effect of incorporation? What is the effect of MOA, AOA? So this story, just one line story. Section numbers 3, 4, 5, 6, 7, 8, 9, 10 you can see here. Once company was incorporated, the next step is commencement of business. For commencement of business, company should have registered office. In front of registered office, you can see, at the entrance of registered office, you can see, I'm sorry, it's not in front. At the entrance of registered office, you can see name board. That name can be changed because of two reasons: voluntarily, compulsory. Compulsory means rectification of name, section 16. Voluntary change of name, both the cases you need to alter MOA, you need to alter AOA, and alteration shall be noted. So altered MOA section 13, 1 plus 3 equal to 4, that you can see original MOA. Altered AOA 14, 1 plus 4 is equal to 5, that you can see in original AOA. Clear? So alteration to be noted, section 15. Compulsory change of name, section 16. Now you can see here company documents. Copies of documents. If any member requests for documents, the document shall be served within 7 days of written request and deposit of sufficient fees. That is section 17. Conversion of companies, private to public, public to private, section 18. Subsidiary not to hold shares, 19. Service of documents, 20. Signing of documents, section 21. Signing of negotiable instruments, 22. Here company documents, remember CS. C, copy of documents, conversion. Yes, subsidiary, service, signing. So 2C, 3S. So with this, we completed incorporation of company. So if you have any doubt with respect to incorporation of company, so you can ask me. So fine. So I covered all the sections, all the sections, all the important information, all the content that is necessary for examination. Yes, I covered just in a span of 58 minutes. So we completed chapter number 2. So you can also go through the concept notes. So you can also go through these concept notes. So each and every point I covered. Yeah. So chalo. So we'll proceed with the next chapter. Our next chapter is prospectus and allotment of securities. So coming to incorporation document, minute changes are there. So whether same wording in textbook should be followed, sir, or I can just remember keywords. Sima, technical words, nothing but keywords, you have to reproduce as it is. So remaining content you can write on your own. And if you see this particular notes, it consists of only technical words. Okay, no? So technical words reproduce as it is, don't take risk. Whereas other content, sentence formation, for example, sentence formation, you can write it in your own words, but technical words should be present. So small changes are there in this copy. So two concepts were duplicated. So I'll delete those two things and final copy I'll share it with you. Okay. So before I start tomorrow lecture, before I start tomorrow marathon, I will rectify these things. The same will be uploaded in the Google Drive. The link also will be shared with you. Don't worry. These copies are with you only. Maybe half day or 1 day delay will happen. Don't worry. Just participate in this marathon lecture. Only when you participate in this marathon, you can get maximum benefit of these handwritten notes. How to read these marathon notes, you will get it. Okay. So without any delay, let's start the next chapter, prospectus and allotment of securities. Clear? Okay, ma. So fine. Let's continue with the next chapter, prospectus and allotment of securities. So before I start, one small announcement, one small point, a disclaimer. It's not announcement, it's a disclaimer. So don't go through this book directly, don't jump into this book directly, because how to read this book is all about this marathon. So at least with 1.5x speed or 2x speed, watch it, then go and read this. So then only you will get maximum benefit. Okay, fine. So our next chapter is prospectus and allotment of securities. The expected weightage of this chapter in your examination is same 5 to 7 marks. 5 to 7 marks. Minimum 5 marks you can expect. Any MCQ coming from this chapter, plus 2 marks. So 7 marks you can expect from this chapter. Let's see. Starting with section 23. Section 23, public offer and private placement. Public offer and private placement. So public companies, they had 3 different modes for offering its securities to the public by issuing prospectus, to the identified persons through private placement, to the existing members, under rights issue. For private company, out of these three modes, only two modes are available. What are those two modes? Identified persons and existing members. Section 2 clause 68. Private company is prohibited from inviting public to subscribe or purchase its shares. Clear? So private company can never invite public to subscribe its securities. So therefore public option is not there. Next one. Prescribed class of public companies can list their securities on permitted stock exchanges. SE means stock exchanges. Permitted. So that are permissible in foreign jurisdiction. Now coming to powers of CG. CG may notify certain class of public companies exempted from complying with chapter 3 prospectus, chapter 4 share capital, section 89, section 90 beneficial owners, significant beneficial owners, and section 127, that is punishment for non-payment of declared dividend. So public offer, prospectus is required for each and every public offer. Prospectus is required. So here public offer includes IPO, FPO and OFS, offer for sale of securities. Next one, coming to the securities definition. Securities includes shares, scrip, stock, bonds, debentures, debenture stock, marketable securities, mutual funds and mutual fund scheme units. Even derivatives are also securities. Security receipt under SURFACI Act is also a security. Certificate by special purpose distinct entity, special purpose vehicles distinct entity, those certificates are also comes under securities. Collective investment scheme units, security. Government securities, security. Rights interest, security. Notified instruments, also security. I don't know whether you remember these points or not, but you have to remember this particular point. Unit linked insurance policy is not a security. Unit linked insurance policy is not a security. So this insurance policy, it consists of both risk plus return. Unit linked insurance policy. So any security where it is taking care of your risk and your returns, then such instrument, such unit linked insurance policy is not treated as security. Simply any tradable instrument is a security. Any tradable instrument is a security. Unit linked insurance policy is not a security. Next one, section 24. Section 24. Powers of CG and powers of SEBI. Listed company in the process of listing, coming to issue of securities, transfer of securities, non-payment of declared dividend, these three matters in these two companies are regulated by SEBI, and all the other matters and all the matters of other companies are regulated by central government. And next one, prospectus means any document described or issued as a prospectus, and prospectus includes shelf prospectus, red herring prospectus, deemed prospectus. So any document described or issued as a prospectus is a prospectus, and it includes shelf, red herring, deemed. What is a deemed prospectus? Any circular or advertisement or notice or any other document. The name might be anything, but if it is inviting offers from the public, for purchase or subscription of securities, then it becomes a prospectus. Forget about the name. The purpose is inviting offers from the public for purchase or subscription of securities of a body corporate, then the document is deemed to be prospectus. So here we will see listed company, unlisted company definitions. We need to see these two, but don't worry. We had a chapter, first chapter, that is a preliminary. In preliminary, I'll discuss with you what is a listed, what is a unlisted company. Clear? Next, section 25. Section 25. What is section 25? A deemed prospectus. So when deemed prospectus is applicable? Oh God, yeah, see here. A company allotted shares to issue house, or company agreed to allot its securities to the issue house. Issue house, if they offer the same securities for sale to the public, then this offer is deemed to be the public offer. Of course, this is deemed to be public offer in only two cases. What are those two cases? Case 1, such offer was made within 6 months of allotment or agreement to allot. Within 6 months of allotment or agreement to allot. A second case, whole consideration by issue house not yet discharged. Whole consideration by issue house to the company not yet discharged. Any one condition satisfied, then that offer for sale is deemed to be public offer and deemed prospectus provisions will apply. Now coming to deemed prospectus, this one extra point you have to remember, ma. So issue house, if issue house is signing the prospectus, then you have to check what is the status of the issue house. If issue house is a firm, at least half of the partners should sign the deemed prospectus. If issue house is a company, 2 directors shall sign the deemed prospectus. So this point is connected with deemed prospectus. Okay. So every prospectus shall be dated, shall be signed. It should contain information and reports on financial information as may be specified by SEBI in consultation with central government. So this is the matters to be stated in the prospectus. Next one, apart from this information, there should be a declaration of compliance. Nothing in this prospectus is contrary to Companies Act, Securities Contract Regulation Act 1956, SEBI Act 1992, rules and regulations made thereunder. So remember these three laws, remember these three acts: Companies Act, Securities Contract Regulation Act, SEBI Act 1992. Clear? Next one, the prospectus is not applicable to existing, when an offer was made to existing members or when an offer is made to existing debenture holders, prospectus is not applicable. And similarly, when securities offered, which is uniform in all respects with the securities which were previously offered and previously those securities were listed on recognized stock exchanges. So now I am offering the securities. These are not new securities. These securities belong to a class which was previously issued to the public, previously listed on the recognized stock exchange. Now for these securities, even though I am offering to the public, prospectus is not applicable. Okay, now next one, these 3 and 4 points are connected to deemed prospectus, ma. In the final copy, these corrections I'll do it, don't worry. Now listen carefully. 3 and 4, these 3 and 4 points are connected with deemed prospectus. So next one, contents of the deemed prospectus is equal to contents specified under section 26. That means this one, first one. Next one, net consideration received or receivable by the company from issue house, time and place of inspection of the contractual documents. So these are the contents of the deemed prospectus. And who will sign the deemed prospectus? Issue house management. If issue house is a partnership firm, at least half of the partners should sign it. If issue house is a company, 2 directors shall sign it. And these people are deemed to be the directors authorizing the issue of prospectus. Next one, ma. 5, 6, 7, 8 points. These 5, 6, 7, 8 points are connected to section 26 only. Let's see. Fifth point. Sir, can I include expert statement in the prospectus? No. But if these 3 conditions are satisfied, then you can include expert statement. What 3 conditions are? Person not engaged or not interested in the company's formation, promotion, management, and he should have given a written consent to include his statement into the prospectus, and he should not withdraw his consent till a copy has been filed with ROC. So you have to disclose the same in the prospectus. Then you can add expert statement also. So disclosures shall be filed with ROC. You have to make a disclosure on the face of the prospectus stating that a copy of prospectus has already been filed with ROC, and also mention the list of documents attached with the copy of prospectus. Now the readers of prospectus will go through these documents. And once prospectus was filed with ROC, it will have a validity period of 90 days. Once a copy has been filed with ROC, prospectus will have a validity period of 90 days. Within 90 days, issue copy to the public, or else the prospectus will be expired. Any provision contravention, company or party who authorizes such issue of prospectus will get a punishment. The fine is 50,000 to 3 lakhs. So in this entire content, 3 and 4 are connected with the deemed prospectus. So I'll separate these 3 and 4 points. I'll add it above. That's it. Over. Next one, section 27, variation in terms of the prospectus. Variation in terms of the prospectus, or variation in the object, variation of objects in the prospectus. First, you have to give a notice to the members, which should contain a prescribed details, and you need to publish that notice in 2 newspapers, English and vernacular newspaper, as well as publish it on company's website. Now, obtain a special resolution from the members. The dissenting shareholders shall be given an exit offer by the promoters or controlling shareholders as per SEBI regulations only. Now, even after getting approval also, you are prohibited from carrying this activity. This is strictly prohibited. Sir, what is prohibited, sir? Even with members approval also, you cannot use that money for speculation activities. That means trading in equity shares of other listed companies. This strictly prohibited. So that is all about section 27 ma. Now coming to 28. Here certain members of the company will authorize company to sell their shares to the public. Now company will offer these members shares under OFS to the public. This is deemed to be public offer. So section 26 is applicable. Matters to be stated in the prospectus. Section 26 is applicable. 34 criminal liability, 35 civil liability is also applicable. Next one, and members who authorize company to members who authorize company to sell their holdings, these people are responsible to reimburse all the expenses incurred by company in this process. So that is all about section 28. Section 29, issue of securities in demat form. Securities in demat form mandatory for these two companies making public offer and prescribed unlisted companies, whereas other companies demat form is just optional. Next one, section 30 is about advertisement of prospectus. In advertisement you will see MOA contents plus capital structure of the company. See, there is no compulsion on the company to advertise its prospectus, but if it is going with an advertisement option, then along with that advertisement, in that advertisement you have to publish MOA content. Simply name, next one, object, capital, liability, association, subscription. You have to mention this information. In addition, you have to mention capital structure of the company, debt component how much, equity component how much. Next one ma, section 31, shelf prospectus. Okay, so shelf prospectus is missing, don't worry. So only for shelf prospectus I'll show you my concept notes. Just a minute. So here itself, let's see these points ma. Very important point ma. This is very important. I predict this comes in our attempt. Let's see here itself. A listed company means any of its securities listed on recognized stock exchange is a listed company. But these 3 companies are not listed companies. Which 3 companies? A public company which has not listed their equity share but have listed following securities. Simply the combination is like this ma. The combination, if you see, the combination is equity unlisted, whereas non-convertible debt listed, or non-convertible redeemable preference shares listed. But how these securities were offered to the public? How these securities were offered? Sir, these securities were offered under private placement only, sir. Under private placement only. Then this is not a listed company. The condition is equity should be unlisted. Debentures, preference shares which were offered under private placement, and if they are unlisted, if they are non-convertible securities. Now these non-convertible securities which were offered under private placement basis, even though they were listed on the stock exchanges, it is no more a listed company. It is not a listed company. Similarly, private company, you see, equity definitely unlisted, whereas preference shares, that too non-convertible, sorry, it's not preference, it's a non-convertible debt security which was offered under private placement basis, and only this debenture was listed on the recognized stock exchange, then also the company is a unlisted company only. Okay, now see how they are offering securities, private placement only. Then they are prohibited from public offer. So private placement only. Even foreign listings, public company, equity unlisted in India. Equity unlisted in India, but those equity shares were listed in foreign jurisdictions. Then also it is an unlisted company only. So this is very, very, very important. Go through it. Next, section 31. I don't know how it is missing. I'll add it. Nothing to worry. So section 31, shelf prospectus. Shelf prospectus. Need for shelf prospectus. For each public offer, one prospectus is required. Correct? For each public offer, one prospectus is required. But shelf prospectus, once prospectus is issued, it will have a validity period of 1 year. It will have a validity period of 1 year. That 1 year validity period is not from date of issue of prospectus. That 1 year validity period counts from date of first public offer under the shelf prospectus. When they are making first public offer under the shelf prospectus, from that date onwards, count 1 year will start. Now for subsequent public offers, for every subsequent public offers, company has to give an information memorandum. It should be filed with ROC at least 1 month prior to the second or subsequent public offer. And in this information memorandum, this information, material facts about the new charges, changes in the financial position of the company, these two contents you will see in information memorandum. Now shelf prospectus plus information memorandum is equal to prospectus. In one attempt, in the same way question was tested. In the same way, shelf prospectus plus information memorandum is deemed to be prospectus comment. So now you have to write this point. Shelf prospectus will have a validity period of 1 year from the date of first public offer under the shelf prospectus. And remember, this information memorandum shall be filed at least 1 month before second or subsequent public offer. This time limit is important. Another time limit: if any applicant wishes to withdraw after the changes are made known, then company shall refund all subscription amounts within 15 days. Within 15 days of availing the option. So any person who deposited money in advance, who filed an application in advance, he should be given withdrawal option. If he exercise withdrawal option, then within 15 days refund those monies. So these are the important time limits. 1 year validity period. Next, 1 month before subsequent offer, file information memorandum copy with ROC. Next one, 15 days withdrawal option. If he exercise withdrawal option, within 15 days refund shall be made. That is all about shelf prospectus. Now come back. Yeah. Next one is red herring prospectus. Red herring prospectus. In red herring prospectus, you will find two prospectus documents. One is red herring, another one is final prospectus. So this prospectus does not contain complete particulars, that is price or quantum of securities. At the timing of issue, company will issue red herring prospectus before final prospectus. A copy should be filed with ROC at least 3 days before opening of subscription. At least 3 days before opening of subscription, company has to file a copy with ROC. And same obligations 26, 34, 35 will apply. Variations shall be highlighted. Red herring prospectus, final prospectus, the variation shall be highlighted. Filings with ROC once offer is closed, subscription period is closed. Now prepare final prospectus, file a copy of final prospectus with both ROC and SEBI. So book building is a price discovery method under section 32. Next one, 33, abridged prospectus. This is not a full prospectus, this is a summary prospectus, a fast track prospectus. It contains salient features of a prospectus as may be specified by SEBI. application form accompanied by abridged prospectus. If any member, this abridged prospectus is not applicable in two cases. If you are inviting underwriters for underwriting, or if issue was not offered to the public, in these two cases abridged prospectus is not required. Next one, copy of prospectus shall be furnished to the requested person. Any person requests for full prospectus, yes, a copy should be delivered to that requested person. And in case of default, for each default, the punishment is 50,000 to the company. Next one, misstatement. Misstatement means what? Either untrue or misleading, omission of any matter likely to mislead. We call it as misstatement. Then what is the effect of misstatement? A criminal liability or a civil liability? Criminal liability or a civil liability? It's not or, it may be and also. It may be and. Criminal liability is applicable when there is a misstatement in the prospectus. The punishment is section 447. If you want to take defense, the defense is prove that misstatement is immaterial, or prove that you had a reasonable grounds to believe up to the time of issue the prospectus contains only correct information. Sir, I had a evidence. Now show me that evidence. If you are taking any one such defense, you will be exempted, you will not be punished. Next, you can see few examples for misstatements. False statements, hiding truth, ambiguous statements, confusing, misleading, all these are misstatements only. The punishment 447. Now, in addition to misstatement, any person who subscribed securities on the faith of prospectus and incurred any loss or damage, then the punishment is a civil liability. A civil liability. That means if civil liability is applicable, that means criminal liability already applicable, because for misstatement criminal liability is there. For misstatement criminal liability is there. Then when civil liability is applicable? Civil liability is applicable only when there is a misstatement and upon faith of prospectus any person subscribed the securities and finally incurred loss or damage. What is the punishment? The persons involved in such a issue has to compensate losses without any limit. So how much loss subscribers suffered, that loss these people have to compensate. A defense. If you take any of this defense, if you fall in any of this defense, no need of punishment, no punishment. Either withdraw the consent before issue of prospectus. No sir, prospectus was already issued to the public. Now what remedy is available to me? Give a public notice. Tell that wrongly your name was included in the prospectus. Tell to the public. And at least you should prove that, sir, I believed expert. Expert is having a knowledge. Expert gave a statement. Expert, on the faith of expert statement, I gave my consent to the prospectus. Like that, take any one stand. If you take any one stand, you will be exempted from civil liability punishment. Criminal liability is applicable to the people involved in such people authorized issue of such prospectus, whereas civil liability is applicable to not only the people authorized issue of prospectus but also company, and the nature of liability is joint and several. Next one, section 34, 35 over. Next, section 36. So this section 36 is applicable to stockbrokers. For example, Harshad Mehta sir, not Harshad Mehta sir, but I am telling you example. So here, any person inducing a person to invest money into particular security. So any statement or promise or forecast which is a false, deceptive, misleading, such statements were made to attract another person to enter into an agreement for acquiring securities, disposing securities, subscribing, underwriting securities, or secure profit from the yield of securities with a minute fluctuations in securities value. Small fluctuations also they will gain crores of rupees. Or obtaining credit facilities from any bank or financial institutions. Your motive might be either A or B or C. Then you will get punishment under section 447. Say I'm making up some false statements. This is not connected with prospectus independently. I'm making false statements. In such a case, the objective is either A or B or C. Then person will get punishment under section 447. Next, section 37 ma, action by affected parties, suffering parties. Any single person or group of persons or association of persons can claim remedy under section 35, civil liability, compensating the losses of the investors. Okay, so action by affected persons, this is a class action suit. So each and every member filing a separate case not required, group of persons filing a one case enough. Next one, section 38, punishment for personation for acquisition of securities. A single person filing application in the name of fictitious person, a single person filing multiple applications in different combination of his or her names, or single person inducing company to allot securities or to register securities in his name or in her name, then for personation the punishment is section 447. And you have to disclose this section punishment in the prospectus. And if any person was convicted, if it was proved that person contravened section 38, even though after disclosure also that fellow doing a personation for acquisition of securities, changing the identity to get more and more securities, then whatever profits he enjoyed, they will be taken back and they will be transferred to IEPF. And even all the securities shall also be transferred to, all the securities lying in his possession shall be transferred to IEPF account. So that is all about section 38. Next, section 39, allotment of securities. First of all, here you can see three activities. Company will give prospectus, it invites public to subscribe its securities. Interested public filing application is nothing but offer, and company if interested will make an allotment, that is acceptance. So prospectus is an invitation to offer, and applications filed by the public is an offer. Allotment to the public is nothing but acceptance by the company. Next one, allotment. What is meant by allotment? An act of appropriation out of previously unappropriated capital of the company. Allotment meaning an act of appropriation by the company out of previously unappropriated capital of the company. For making allotment, two conditions must and should to be satisfied. First one, minimum subscription. Second one, minimum application money. How much is minimum subscription, sir? And what is minimum subscription? Any amount mentioned in prospectus as minimum subscription will be the minimum subscription. Any amount received by the company by way of check or any other instrument, sorry, it's not, one second. Amount stated in the prospectus, but that amount should not be 90%, less than 90%. That amount should be at least 90% of the public offer. At least 90% of the public offer. And next one, applicants should deposit application money only through banking channel, that is by way of check or by way of account paid transaction. Cash mode is not allowed. So this is a separate condition. Next one, minimum application money. At least 25% of the nominal value of the security or any percentage specified by SEBI. So that is the minimum application money. Company should receive minimum application money. So for making allotment, how many conditions to be satisfied? Two conditions. One is minimum subscription. Second one is minimum application money. If these conditions are not satisfied within 30 days from date of issue of prospectus, then refund within 15 days from the issue closure date. Refund all the application money within 15 days from the date of closure of issue. In case of delay, officers in default gets punishment. What is the punishment? They need to pay interest. How much? 15% per annum. It's not company. Officers in default will pay interest. Suppose these two conditions have been satisfied, then proceed with allotment. In case of allotment, company should file PAS 3. It's PAS 3. Company should file PAS 3 within 30 days of allotment with ROC. In case of non-compliance, the punishment for company 1000 per day during such default continues up to 1 lakh, and the same punishment is also applicable to officer in default. So that is all about section 39. Now coming to section 40. Securities to be dealt with in stock exchanges. So before making allotment of securities, the company's securities should be listed on recognized stock exchange. At least on principal basis, company should obtain approval from the stock exchanges. So they need to file an application with at least one or more stock exchanges, obtain permission for listing before making offer, and disclose the names of stock exchanges in the prospectus with whom you filed an application. Next, application money. For receiving application money, open a separate bank account. So the amount in this bank account shall be utilized only for two purposes, either adjustment against allotment or refund if you are unable to allot. In case of default, minimum 5 lakhs, maximum 50 lakhs punishment to the company. Officer in default, minimum 50,000, maximum 3 lakhs. And in prospectus, if you find any clause, agreement, restraint of legal proceedings, any clause which restraint legal proceedings, that clause becomes void. The effect of the clause is void. Next one, payment of underwriting commission. For payment of underwriting commission, you have to check the following conditions. First one, you need to see whether AOA authorization is there or not. If not, follow section 14, alter AOA, pass special resolution, alter AOA, insert underwriting commission related clauses. Next, coming to the sources, company can utilize company profits or issue proceeds or both for payment of underwriting commission. Coming to the rate of commission, rate mentioned in AOA or 5% of the issue price for shares, 2.5% of issue price for debentures, whichever is lower. If the securities are not offered to the public, underwriting commission is not allowed. Suppose 80% offered to public, 20% offered to the promoters. Now the securities 20% which was not offered to the public, on that underwriting commission is not allowed. Disclosures and filings with the ROC. So details of the underwriter, extent of underwriting, everything should be communicated. You should be filed with ROC. So that's all about underwriting commission, section 40. Next, section 41, global depository receipts. Just remember this picture. First, company will allot shares in the name of overseas depository, but the custody of shares will be given to domestic custodian bank. And domestic custodian bank will enter into a custodian agreement with the overseas depository. Based on this underlying assets, overseas depository will offer receipts to overseas investors. So these receipts issued by depository, DRs, traded globally called as GDRs. For GDRs, board resolution, member special resolution is required. Most important point in global depository receipts is who will exercise voting rights. Who exercise voting rights? Until conversion of GDR into share, overseas depository will exercise voting. Upon conversion, holders of shares will exercise voting rights. So this is a tricky point. Next one, last concept, private placement. In private placement, board of directors will select a group of persons, maximum 200 per financial year, maximum 200 persons per financial year, and they will be given private placement offer come application letters. If they are interested, they will invest money. Against that investments, company will allot securities. So conditions, first, obtain special resolution. Suppose offered securities are non-convertible debentures which are within the limits of section 180 subsection 1 clause C. Within the limits, that is existing plus proposed debt. If it is up to 100% of paid up share capital free reserve securities premium, then board resolution alone is enough. Next one, identified persons. So the selected group of persons, identified persons are up to 200 only. This limit of 200 is applicable per security, per financial year, and this limit of 200, while counting 200, this two people are excluded: qualified institutional buyers and employees under ESOP. Even if directors are covered under ESOP, they are also excluded. And this limit of 200 is not applicable to NBFC, housing finance companies, and NBFC housing finance companies. Next one, if company is making an offer beyond 200 persons, then it is deemed to be public offer. Section 23 to section 40 shall be made applicable. Next one, private placement offer cum application letter. Private placement offer cum application letter PAS4 shall be sent to all the identified persons within 30 days of recording their names. Within 30 days of recording their names, PAS4 shall be sent to all the identified persons. Renunciation not available. Advertisement also not available. Strictly prohibited, because this is a private placement. And interested candidates will deposit application money. Money should come from the persons whose names were mentioned in the list, not outsiders. Even family members also not allowed. Money should come from the persons. Money should come from the persons whose names are mentioned in the list. So application money shall be deposited in a separate bank account, and that money shall be utilized against any of the following two purposes. If you are proceeding with allotment, adjust against allotment. No allotment, sir, then refund all the application money. And what is the time limit for allotment? 60 days of receipt of application money. When I receive application money, from that date onwards, within 60 days, I need to make allotment. If not, refund within 15 days after expiry of 60 days. If not, it is treated as deposit. So after expiry of 60th day, that means from 61st day onwards, pay interest. Who will pay interest? Company. How much rate of interest? 12% per annum. Suppose if company allotted shares, then company should file PAS3 with ROC within 15 days of allotment. In case of joint holders, amounts shall come from the bank account of first named person. In case of default, this is the punishment. Default of non-filing of PAS3, default in non-filing of PAS3, or delay in filing of PAS3. So the punishment is 1000 per day up to 25 lakhs. For company, promoters, directors, the same fine, 1000 per day up to 25 lakhs. Non-compliance with section 42, then company, promoters, directors will get a punishment. How much punishment? Amount raised or 2 crores, whichever is lower. This is the punishment to the company, promoters, directors for non-compliance with section 42 private placement. So in private placement, you have to remember these limits: 200 per financial year, per security. While counting 200, QIB employees are excluded. These limits are not applicable to non-banking financial companies, housing finance companies. Remember this, that's it. Next one, so here you can see form numbers PS 1, 2, 3, 4, 5. One is for advertisement of notice for changing objects of prospectus. PS2 information memorandum. PS3 written off allotment. 4 private placement offer cum application letter. PS5 that is private placement record of private placement. So in this prospectus and allotment of securities, you can see 20 sections. How many sections? 20. Prospectus 23 to 41, private placement 42. So 23 public offer private placement, 24 powers of CG and SEBI. Now under prospectus you can see two branches: requirements, types. Requirements: contents of the prospectus, variation of prospectus, issued securities or offered securities should be in demat form, advertisement of prospectus. 26, 27, 29, 30. Whereas types of prospectus, simple. Remember a cheat code: DOSRA, deemed prospectus 25, offer for sale 28, shell prospectus 31, red herring prospectus 32, abridged prospectus 33. And for fraud, misstatements in prospectus, criminal liability 34, civil liability 35. Punishment to the defaulter, section 36. Rights of the aggrieved party, section 37. Next one, securities, remember cheat code Parley G. Parley G biscuit, P stands for personation, A stands for allotment, R stands for recognized stock exchange, and G stands for global depository receipts. And section 42 is all about private placement. So this is all about prospectus and allotment of securities. Only two concepts are missing in this handwritten notes. One is shell prospectus and the other one is listed company, unlisted company. I'll add these two things. I'll upload it. Okay. So just 2 minutes break before I start the next topic, share capital. So you can ask me doubts. First of all, so this is my contact number. You just send your doubts. You can ask me your doubts in Telegram. Prefer Telegram because WhatsApp, my clients, I'm also a practicing chartered accountant. So generally clients will send documents or data in WhatsApp. So if you have any doubts, reach me on Telegram. My Telegram number is 7799081105. When will you share PDF, sir? I'll take a hard copy. See, corrections are there. I'll do it. So these 3 chapters related PDF, I'll upload it on the Google Drive. The link will be given in the video description. Don't worry. For the time being, the link which is there in the description is not working. Yes, I know. That's a old link. I'll update it. Once these 3 chapters are finalized, I'll update it. Next, how to score good marks with the help of this material. See, this is a marathon lecture. This is not a substitute to the class lectures. First of all, who should watch marathons? At least if you have completed one time reading, one revision. And if you are having a problem to revise the subject, hundreds of the pages, unable to revise it within a short span of time. For you, marathons are solutions. So don't substitute marathon lecture with the class recording lecture, because class recording lectures are generally 100+ hours. Including question bank, it is of 105 hours. So only with marathon scoring good marks, I won't suggest. First of all, this is just for revising the voluminous content in the short duration. So next chapter is share capital. Of course, it looks lengthy, nothing to worry. I'll do revision in just 50-55 minutes. I won't take much time. Next 50-55 minutes I'll complete share capital chapter also. Okay. And coming to tomorrow's agenda, I'll cover chapter 5 deposits, chapter 6 charges, 7 management and administration, and general clauses act. These 4 chapters I'm going to cover tomorrow. If time permits, I will also add one more chapter, that is dividends. But I hope time will not permit. Reason, chapter number 7 is management and administration, a lengthy chapter, right? So the tomorrow agenda would be mostly 5, 6, 7 general clauses act. Coming to the weightage, each chapter 5 marks management and administration 10 marks, general clauses act roughly 14 marks. So 14 plus 10 plus 10, So approximately 34 hours. Sorry. Approximately 34 marks. That is our tomorrow's agenda. Chapter 5, 6, 7. What is 5? Deposit. 6, charges. Small chapters. I think both the chapters will not take more than half an hour also. And 7th one is MGT and General Clauses Act. So 34 marks. And tomorrow, today, if you see, I covered already 2-3 topics, 2-3 chapters, and 4th chapter also I'll cover. The rough weightage, if you see, imagine from all these chapters expecting 7 marks. So 21 marks is the weightage of these 3 chapters which I'm covering today. So once this marathon lecture over, I need to spend some time on finalizing chapter 5, 6, 7 and General Clauses Act handwritten notes. At the same time, I'll do small corrections in these documents also, okay? Enough? Is break enough? Can I start? So just comment below. Can I start? Can I resume? Yes. Next chapter is share capital and debentures. Let's continue our marathon with the next topic, share capital and debentures. As usual, before I start, again a small disclaimer. Marathons are not a substitute to classroom lectures. These marathons are only meant for a revision purpose. Sir, I completed already one time reading. I already completed one time revision. But I'm finding some difficulties, sir, in revising the voluminous subject. The book is of hundreds of pages, sir. So I'm facing a small problem, or I'm facing a problem in revising the voluminous content. Then only use marathons. Okay, fine ma. Chalo, next chapter, share capital and debentures. So this chapter is one of the biggest chapter in the entire Companies Act. In this chapter you will see total 30 sections. At the end of the chapter you can see all the 30 sections chart. You can see sections, all 30 sections chart also there. So for easy remembering section numbers, this chart has been given, this chart has been provided to you. Yeah. Chalo, beginning onwards. First of all, what is a share? Share means share in the share capital of the company, and it includes a stock. What is the difference between share and stock? Share, it's a unit of capital. It may be partly paid up, it may be fully paid up, and it will be issued directly. Company will issue share directly. But coming to the stock, stock is bundle of shares. It's a collection of shares, bundle of shares. Stock, only fully paid up shares can be converted into stock. Partly paid up shares can't be converted into stock. Only fully paid up shares can be converted into the stock. And it cannot be issued directly. Only fully paid up shares can be converted into the stock. Coming to the kinds of share capital, we are having two kinds of share capital, equity, preference. Equity share capital, it's a share capital other than preference share capital. Next, preference share capital means a share capital that carries preferential rights over equity shareholders. One is with respect to dividend, the next one is redemption. Whether participatory rights are there or not, if a preferential right was given, then that share capital is a preferential share capital, preference share capital. So compared with equity shareholders, these shares carry preferential rights, priorities. Next one, coming to equity share capital. equity shares are of two types: ordinary shares, differential rights. Ordinary shares, differential rights. First one, issue of equity shares with the differential rights. What are the conditions to be satisfied for issue of equity shares with the differential rights? What are the conditions to be satisfied? The first one is articles of association authorization. Next, approval from the members, ordinary resolution. Ordinary resolution, members' approval is required. How such resolution should be passed? Call for a general meeting and obtain ordinary resolution. But if you are a listed company, such ordinary resolution shall be passed through postal ballot. In examination they will ask you a question like this: a T limited company whose equity shares were listed on recognized stock exchange planned to issue equity shares with differential rights. For that purpose, company called general meeting, and at that general meeting ordinary resolution has been passed. Whether resolution is valid or not, resolution is invalid. Why invalid? Because such resolution by a listed company should be passed via postal ballot. Next, limit maximum issue of equity shares with the differential rights. Issue of equity shares with the differential rights shall be restricted with 74% of the total voting power. Maximum 74% of the total voting power. So ordinary shares 26%, differential rights voting power maximum 74%, 26, 74, 100. And company should not have following defaults. Here you can see defaults, two categories: no subsisting default, no time defaults. No subsisting default, no time defaults. Subsisting, that means at the time of issue of equity shares with the differential rights, at the time of issue, company should not have these defaults. What are the defaults? Declared dividend non-payment, redemption of preference share capital, debentures matured but not redeemed, interest on debentures not paid, deposits matured but not paid, interest on deposits not paid. Any default is there, rectify, then issue equity shares with differential rights. Now coming to the time defaults. Time defaults are of two types: 3 years, 5 years. 3 years, last 3 years company should not have these defaults. Which defaults? Filings with ROC. Company should be regular in filing with ROC, and company should not be penalized by RBI, SEBI, FEMA, under FEMA Act, under Securities Contract Regulation Act during the last 3 financial years. If penalized, if financial statements or annual returns not filed, then wait for 3 years. That's it. 5 years means what? If company has committed these defaults, repayment of term loans, payment of interest, payment of preference dividend, and employee statutory dues payments, IEPF transfers default. Any of this default is there, first rectify. In which year you rectified? Sir, suppose I rectified in 2020, for example, in 2020. To this financial year, add 5 years. 5 years ban, simply 5 years ban. After 5 years, that means after 2025, 26 financial year, 26 financial year onwards, company can issue equity shares with differential rights. Next, other points you can see. How to remember these defaults? Simply remember sources of finance. Sources of finance, if you see, equity share capital. With respect to equity share capital, company may commit a default of payment of declared dividend. Preference share capital, two defaults. One is dividend, other one is capital. Next one, debentures. Next one, deposits. Next one, term loans. Up to deposits, debentures, write under subsisting defaults. Of course, preference share capital dividend, write it under 5 years defaults. So term loans, next one, preference share dividend, next employee statutory dues, next one IEPF transfers. So these 4, term loan interest also there. So these 5, it's not a default year important, it's year of rectification important. When rectified, from that year of rectification, wait for 5 years. After 5 years, after expiry of 5 years, you can proceed with issue of equity shares with differential rights. And other important points, notice an explanatory statement contains conversion is prohibited. Ordinary shares to differential rights, or differential rights to ordinary shares prohibited. Automatic conversion is not there. At least you take ordinary shares. Now allot differential rights if they apply. Disclosures in board report. Rights of equity shareholders. There is no right. There is no change in rights except bonus, except rights issue. Under rights issue, under bonus, the shareholder will get same class of shares which he is holding, and particulars to be maintained in the registers. Note: Section 43 shall not apply to IFSC companies and private companies if MOA AOA provides so. If MOA, if in AOA it was clearly mentioned Section 43 is not applicable to us, then 43 is not applicable. If AOA is silent, then Section 43 is applicable. So that is all about Section 43. Next, Section 46. Section 46, share certificate. Share certificate. Format, Form SH1. It's a prima facie evidence of title, record of depository for demat shares. Share certificate issued under common seal. Share certificate shall be issued under common seal. No common seal, don't worry, 2 directors or 1 director and 1 company secretary signing it, enough. Common seal is there, fix common seal. If common seal is not there, no need to fix common seal. But 2 directors signature, 1 director and 1 company secretary signature is mandatory. Even after affixing common seal also, these people should sign it. Common seal is not substitute to these people's signatures. Along with common seal, 2 signatures will be there. If no common seal means 2 signatures will be there. Duplicate share certificate shall be issued in case original share certificate is lost or destroyed, or original share certificate is damaged or torn. But in case of share certificate lost or destroyed, along with application, submit an indemnity bond. In case of damaged share certificate, file an application and submit original share certificate. No need of indemnity bond. Here, indemnity bond not required. And you have to deposit fees up to 50 rupees per certificate. Company shall issue duplicate share certificate within 45 days if it is a listed company, within 3 months if it is an unlisted company, but disclosure is mandatory. So you have to mention duplicate share certificate issued in lieu of original share certificate number. So disclose it. Next, maintain a separate register SH2 and entry shall be recorded by CS or board authorized person. Next one, with respect to duplicate share certificate. There is a punishment. Just wait. Oh God. So that punishment clause is missing, That punishment clause is missing. I'll add it. So for that only, yes, punishment clause is missing. So what is the punishment, for unauthorized duplicate issue of shares? The punishment is for company. I have verified and I have added that point. Okay, fine. The punishment is, for company, the punishment is a minimum 5 times of face value of shares duplicated, maximum 10 times of face value or 10 crores, whichever is higher. And for officer in default, Section 447 is applicable. For officer in default, Section 447 is applicable. Next one. Section 47, voting rights. Section 47, voting rights. See, for equity shareholders, they are entitled to vote on every resolution, whereas preference shareholders, they are entitled to vote on every resolution only if dividends are not paid for 2 or more years continuously. 2 years consecutively, if dividend was not paid, then preference shareholders will also get voting rights. Or else, preference shareholders' voting rights are restricted to 3 matters. Matters affecting their rights, winding up of the company, reduction of capital of the company. Next one, voting rights. For show of hands, each member is entitled to 1 vote. In case of poll, equity shares with voting rights, 1 share equal to 1 vote. For differential rights, we need to check terms of issue. As per the issue terms, differential rights voting holders of equity shares with the differential rights voting will be determined. Nidhi company, this is the most tricky point. In case of Nidhi company, members voting rights are restricted to 5% only. Even though you are holding 10% of company's capital, your voting right is restricted to 5% only. And section 47 does not apply to IFSC public companies, private companies if AOA provides otherwise. That is a normal point only. Next, section 48 ma variation of shareholders rights. Variation of shareholders rights. This clause is applicable only when company is having different classes of shares. Company should have different classes of shares, and company wants to change rights of a particular class members. Then you have to take a consent from the members. If meeting is possible, pass special resolution. No sir, for me postal ballot is applicable, sir. For me postal ballot is applicable. Then obtain consent from at least 75% of the value of issued shares. 75% of the value of issued shares. And dissenting shareholders can file an application with NCLT. For that, they had a time limit of 21 days, and the eligibility criteria they should satisfy is at least 10% of the class capital they should maintain. At least 10% of the class capital they should maintain. Next one, variation of one class affecting the rights of another class, then you have to take similar consent from other class shareholders also. This is also one more exceptional point only. Already tested 2 attempts back. Okay, for variation you have to check MOA AOA whether MOA AOA permits or not. If MOA AOA is silent, then go with issue terms. There should be no prohibition on variation in the issue terms. And finally if you see, this is one particular point, second point, and last point, if you see, if the shareholders who are against to the variation, they can file an appeal. They can file a petition with NCLT. NCLT will pass an order, maybe confirming the variation or rejecting the variation. Whether confirmed or rejected, file NCLT order with ROC within 30 days of NCLT order. Next, section 49 to 51. Section 49, calls shall be on uniform basis, and for making calls on shares, board resolution is compulsory. Calls in advance, AOA authorization is required, and company will pay interest as per the rate mentioned in AOA. For calls in advance, there is no extra voting. Remember these points. Next one, 51, payment of dividend. Sir, is this dividend in proportionate to paid up value? That means dividend percentage. Suppose 10% is the dividend rate. Will it be applied on face value or will it be applied on paid up value? If AOA is silent, face value. If AOA provides that dividends will be paid on paid up value only, then we need to follow paid up value. So this is subject to articles of association. Google Drive link is not working. Yes, I know. Just wait for another 3 or 4 hours. I'll finalize this copy and I'll upload it in Google Drive. The new link, I'll share it in the description. Don't worry. Next one, section 52, utilization of securities premium. Here, again I'm telling you, how much I need to fix securities premium, that is up to you. You can fix securities premium, absolute freedom to you. But here, the conditions for utilization of securities premium. So for what purpose I can utilize securities premium? You can see 5, B square, E, P square. What is the condition? B square, E, P square. B square means buyback, bonus issue. E means expenses connected with issue related expenses. P square means premium on redemption, preliminary expenses written off. But if you are a company which is required to prepare financial statements in accordance with accounting standards, then for you securities premium is available only for 3 purposes: bonus shares, buyback, expenses connected with issue, underwriting commission, for example. Okay. Next, if a company is using securities premium other than stated purpose, then instead of debiting securities premium, debit capital account. That means capital reduction provisions shall apply. Next one, prohibition on issue of equity shares at discount. Issue of equity shares at discount is void. Of course, we had a exception, two exceptions. One is sweat equity, the other one is conversion of debt into equity in the following cases. Either under SRP, statutory resolution plan, or debt restructuring scheme. Following RBI guidelines, debt can be converted into equity. At the time, you can issue shares at discount also, no worries. In case of non-compliance, company and officer in default will get a punishment up to 5 lakhs or amount raised through issue of such prospectus, amount raised through issue of shares at discount, whichever is lower. Along with the refund, along with that punishment, there is also a refund. Just wait, let me see whether screen is visible or not. Yeah, along with that punishment, company has to refund that application money. To that, company need to add interest, which is 12% per annum also. Next, that is all about section 53. Yeah, next one, section 54, sweat equity shares. Issue of equity shares at a discount or for a non-cash consideration by company to its employees, directors working in India, outside India, working in our company or holding our subsidiary company, for providing know-how, IP or value additions. So if you see the conditions, special resolution, what is the current market price, to whom we are offering sweat equity shares, and 1 year after incorporation, this is not a condition. Remember, there is no waiting period. Once company was incorporated, company can issue sweat equity shares without any waiting period. Listed companies should follow SEBI, unlisted companies follow Companies Act, and only existing class of shares shall be issued. As sweat equity. New class of shares cannot be offered under sweat equity. Sweat equity shareholders rank pari passu with other shareholders. And here you can see the definition of the employee. Permanent employee, director may be whole time or not. Whole-time director or not. They must work either in India or outside India, in our company or in our subsidiary company or in our holding company. So these points are okay, but if you see the rules, for a sweat equity share, special resolution is pakka needed. And what is the validity of special resolution? 12 months. Within 12 months, allotment of sweat equity shares should be done. Next one. There is a limit on sweat equity. What is the limit? 15% of existing capital or 5 crores, whichever is higher. But during its lifetime, maximum 25% of the capital. Maximum 25%, that's it. Of course, for a startup company, up to 10 years, it's 50%. Up to 10 years after formation, up to 10 years after incorporation, startup companies can go sweat equity shares, which is up to 50% of existing paid up equity share capital. Normal companies 25% only. In a year 15%, maximum 25%, that's it. Lock-in period will be 3 years from the date of allotment. Valuation should be done by registered valuer. For recording entries, the valuation should be taken care by registered valuer. Next one, if company is receiving a depreciable asset, capitalize it or else record it as an expenditure, and final disclosures in the board report, maintenance of the registers. That's it. That's all about section 54, sweat equity shares. So in this, the traps are these limits. These limits are big traps. Can I proceed? Next one, issue and redemption of preference shares, section number 55. For issue of preference shares, these 5 conditions to be satisfied. First one, AOA authorization. Second one, special resolution. At the time of issue of preference shares, company should not commit existing defaults. Company should not have the following defaults. That means there should be no subsisting defaults. One is payment of preference dividend, repayment of preference capital. With these defaults, company cannot issue new preference shares. So rectify them. Next, immediately you can issue preference shares. The preference shares shall be redeemable and maximum tenure is 20 years. Of course, for infra companies, the maximum tenure is 30 years. Of course, from 21st year onwards, every year 10% redemption should start. Next, coming to the redemption, shares to be redeemed must be fully paid up. And coming to the redemption value, yes, redemption value is of two components, nominal value, premium. For face value, company can utilize company profits or company can utilize issue proceeds. If company is utilizing company profits for redeeming face value of a preference share, then the amount so utilized shall be transferred to CRR, capital redemption reserve, which shall be utilized only for the purpose of issuing bonus shares. With respect to premium on redemption of preference shares, utilize company profits or utilize securities premium. Of course, section 133 companies, it's not 123, section 133 companies, securities premium utilization for premium on redemption of preference shares is not allowed. Next one, issue of further redeemable preference shares. Issue of further redeemable preference shares. The situation, company is not in a position to redeem preference shares and company is not in a position to pay preference dividends also. So here the shares are unredeemed preference shares. The shares are unredeemed preference shares. With the consent of 3/4 value holders and with the approval of NCLT, company can convert unredeemed preference shares into new preference shares. So redemption, is it actual redemption or deemed redemption? Deemed redemption. Of course, if dissenting shareholders are there, settle them. Give an exit offer, settle them. So dissenting shareholders, normal settlement. Now in this process, either share capital got increased or reduction happened. Increased share capital or reduced share capital norms will not apply. Reduction of share capital provisions will not apply. Next one, increase, further issue of shares, that concept is also not applicable. So that is all about section 55 ma. Next, section 56, transfer and transmission of securities. Transfer and transmission of securities. In transfer, two parties will be there. One is transferor, other one is transferee. What can be transferred? If your company is company with share capital, securities can be transferred. Company without share capital, ownership interest can be transferred. What are the conditions for transfer? SH4 transfer instrument is required. It should be executed by both transferor and transferee. It should be dated, stamped and delivered to the company within 60 days of execution. Within 60 days of execution of SH4, submit all these documents to the company. If delayed or application form is lost, SH4 was lost or 60 days time period is over, then submit an indemnity bond. Of course, these rules are not applicable in the below three cases. For demat form of securities, and for transmission of securities, for government company securities, these norms are not applicable. Next one, company has to give 2 weeks notice to the member in case, sorry, it's not member, to the transferee. Company should give notice to the transferee. In case shares involved are partly paid up and the application is submitted by transferor. If transferor alone submitted the documents and the shares involved are partly paid up, company should not register the transfer without confirmation. So for that, give 2 weeks notice to the transferee. Today, if you are giving notice, wait for 2 weeks. Within 2 weeks, if there is no response from the transferee, then you can proceed with registration of transfer. In case of transmission, the legal representative shall submit the documents to the company for transmission. Next one, time period for delivery of certificates. Subscribers to MOA, allotment of shares, transfer of securities, subscribers to MOA 2 months from incorporation, allotment of shares 2 months from allotment, transfer of securities within 1 month from the receipt of SH4 by the company, transmission also same time limit 1 month. For debentures allotment, time limit is 6 months, whereas IFSC specified IFSC companies for all the above things the same time limit. What is the time limit? 60 days is the time limit. Next one, for non-compliance of section 56, punishment, company officer in default or depository, whoever might be involved, so 50,000 penalty. For fraud, section 447 is applicable. 57, small section ma, personation as a shareholder, changing the identity for getting more shares, that is 38. This is 57. What is 57? I'm changing my identity in order to claim shares, in order to claim interest which was held by another person. Another person is the real owner of the company, but I'm changing my identity. I'm pretending myself as the real owner of the company. Why are you doing this? In order to obtain some securities or interest, share warrants, coupons. Then the punishment will be imprisonment and fine. Imprisonment 1 to 3 years, fine 1 lakh to 5 lakhs. Next one, in case of forged transfer. In case of forged transfer, you will see 3 parties: original owner to the forged transferee to the innocent transferee. Original owner name will be restored, will be taken back, and he will be given all the benefits which were paid during the period. Forged transferee is liable to indemnify company. Innocent transferee will get compensation from the company. So company is liable to the real owner, and company is also liable to the innocent transferee. But when company is doing all the things, company may be at loss. No sir, yes, that loss, the transferee who was involved in the forgery, will compensate. Next, section 58 and 59. Section 58, refusal of registration and appeal against refusal. Transfer deed has been submitted to the company, but company is not registering the transfer. Company is rejecting the transfer. Now it is the duty of company to send a notice of refusal within 30 days of receipt of SH4 to the transferor or transferee or person making intimation of transmission. Now transferee alone will file an appeal with NCLT. NCLT, after listening to the parties, either dismiss or order the company for rectification. And the time period, if you see, what is the time left with this aggrieved party to file an appeal, sir? No notice of refusal, then the time period is within 60 days of delivery of SH4 to the company, in case of private company. In case of public company, within 90 days of delivery of SH4 with the company. No sir, I received notice of refusal. Then from the date of notice of refusal, within 30 days in case of private company, within 60 days in case of public company. These are the time limits within which one has to file an appeal with NCLT. Of course, NCLT had power to condone the delay also. But remember the time limits. How to remember? I told you many times. 30 plus 30, 60. Next one, 30 plus 60, 90. Here 60 is from delivery of documents, whereas 30 is from notice refusal. Notice of refusal. Next, company NCLT order. Comply NCLT order within 10 days. For contravention, the punishment, imprisonment 1 to 3 years, fine 1 to 5 lakhs. No restriction on rights of the transferee unless voting rights are suspended by NCLT. So these are the rights of transferee. Next, rectification of register of members. Rectification of register of members. So what about this point? So first one, I'm not the member but my name was entered into the register, or I'm member but my name was omitted. So now aggrieved person will file an appeal with NCLT, whether his name may be wrongly entered or wrongly omitted or some unnecessary delay. there is a unnecessary delay from company's end in registering the transfer or in updating the registers. If you are a foreigner, if you are a foreign member, for you NCLT of course not required. You can file a petition with a competent court outside India. Now these people had power to dismiss the appeal, or they may order company to rectify the registers. Okay na? So that's all about section 59. Punishment, as you can see above. A defaulting persons, if they are fraud, if they are doing any fraud, section 447 is applicable. Next, section 60. Almost at the end, almost at the end. Yeah. What is section 60? Publication of authorized share capital. Wherever you publish authorized share capital, there itself you publish subscribed share capital and paid up share capital, or else punishment to the company 10,000, officer in default 5,000 is the punishment. Next, section 61 is power of a limited company to alter its share capital. Power of a limited company to alter its share capital. So to alter its share capital, company should get a power from AOA authorization. Next, ordinary resolution. Ordinary resolution is enough, and we had 5 ways of alteration: increase of capital, consolidate and divide. In this consolidation and division, if there is a changing in voting percentage, get prior approval of NCLT. Shares can be converted to stock, stock can be converted to shares. A split, a decrease of share capital. Decrease is different, reduction of capital is different. For reduction of capital, NCLT approval is required, whereas for decrease, such permissions not required. And in case of split, in what ratio you are splitting the face value, in the same ratio paid up value should also be splitted. Next, section 42. Section 42, a simple section only. Issue of further shares. Issue of further shares to the existing members. For that, prepare letter of offer, a document. Dispatch the document at least 3 days before opening of subscription, and the offer period should be minimum 3 days, maximum 30 days. If you want, renunciation is also there, but AOA prohibition should not be there. If AOA prohibits renunciation, then rights renunciation is not there. You can also go with employees after passing a special resolution. For private company, OR is enough, ordinary resolution is enough. Of course, the company should be regular in complying with section 92, filing of annual returns, section 137, filing of financial statements. And of course, for IFSC public companies also, OR, ordinary resolution is enough. Now coming to rights issue, this duration of 3 days and the duration of 7 days can be reduced in case of private company and IFSC companies, subject to 90% of the members' approval. Subject to 90% of the members' approval, yes, the period of 3 days and the period of 7 days can be reduced. Now coming with outsiders, comply with the norms. The norms are special resolution is compulsory, and for a non-cash consideration, valuation report is also compulsory. Next, section 63. Section 63 is all about bonus shares. Ignore. This is a yes. Here also correction is required. Next, section 62 not yet over. You can see here section 62 is not applicable in the following 2 cases. Section 62 is not applicable in the following 2 cases. If company has issued convertible debentures, now company is converting debentures into equity, or company has issued convertible preference shares, now company is converting preference shares into equity. At the time of conversion, members special resolution is not required. Members special resolution is not required. Directly you can go. And whereas for compulsory conversion, for compulsory conversion of debentures which were issued to the government or loan from the government, so into the equity, yes, when central government orders for conversion, it will be converted. If you want to file an appeal with NCLT within 60 days, and government order itself is enough for increasing the authorized share capital. So that's all about section 62. Time limits also we discussed. Next, section 63, issue of bonus shares. For issue of bonus shares, free reserves. For issue of bonus shares, the available resources are free reserves, securities premium, CRR. revaluation reserve not allowed. And you have to check AOA authorization, board approval, next members approval is required, and company should not have committed in the defaults, following defaults: interest, deposit, debt securities, and employees statutory dues. There should be no default in the following payments or repayments. And only fully paid up shares will be issued as bonus, and fully paid up shareholders are entitled to the bonus shares. I'm holding partly paid up share. Now I'm not entitled to the bonus share. Or I'm holding fully paid up share. Can I get partly paid up bonus share? No. The issued share should be fully paid up, and the person receiving shares, bonus shares, should hold fully paid up shares. And you remember, bonus shares shall not be issued in lieu of declared dividends. Once dividend is declared, once dividend is declared, it should be paid in cash only, kind not allowed. Next, decision of board recommending a bonus issue shall not subsequently withdraw the same. Once board of directors recommend bonus issue, they had no power to withdraw it. Next, section 64. Yes, this is section 64 ma. Whenever company alters capital, redemption of preference share capital, or government order increasing authorized share capital, in all these three cases, file SH7 within 30 days of the event. If not, default, this is the applicable punishment. Next, section 66, reduction of share capital. 67, restrictions on purchase of its shares. 68, buyback. 70, prohibition of buyback, and 71, debentures. So we can complete it now itself. Another 15 minutes, hardly 15 minutes, just participate. Reduction of share capital is different from buyback. So this section is not applicable to buyback. Reduction is possible in three ways. First one, cancellation of unpaid capital. A second one is cancellation of unrepresented capital, and last one is cancellation of unwanted capital. This is unpaid, this is unrepresented, this is unwanted, excess money, pay off and cancel it. For reduction of share capital, what procedure we need to follow? Just see, this section is applicable only to the two companies: company limited by shares, company limited by guarantee with the share capital. File an application with NCLT. Along with the application, attach copy of special resolution, minutes of the meetings, a list of creditors, updated list of creditors, and also attach audit certificate regarding accounting treatment of reduction of capital. Now NCLT shall forward the notice to CG, ROC, SEBI if company is listed, and all the creditors whose details were given in this list. And NCLT will wait for 3 months. Within 3 months, if these people made objections, NCLT will ask company to solve those objections. If at all no objections, then NCLT will check whether creditor dues were discharged or not, at least determined, secured, and finally they were consented or not. If yes, then they will pass an order confirming the reduction of capital. And of course, the company which has committed defaults in repayment of deposits or payment of interest on deposits, for these companies, section 66 reduction of capital privilege is not there. Okay na? Next one, this order should be published into newspapers, publish it on the website, and filing with ROC at least within 30 days of NCLT order. ROC filing, the time limit is 30 days. Now you need to alter the share capital. Now what is the maximum liability of the members? So revised face value and revised paid up value. What is the difference between revised face value and revised paid up value? That is the maximum liability of the members. Now in this case, a chance of fraud is there. Suppose directors are concealing some creditors, hiding some creditor details, or directors are changing the nature of creditors. Suppose they are unsecured creditors, but directors are showing them as secured creditors. Either their nature misrepresented or their amounts were misrepresented. Then the directors will get punishment. Officer in default will get punishment under section 447, whereas members will get the punishment. What is the punishment? They will get back their original liability. They are liable for original amounts. I mean before reduction what would be the original liability, that liability will be given back. That's all about section 66. Next 67, restrictions on purchase by company or giving of loans by company for purchase of its shares. So this section is applicable to two companies only, company limited by shares and company limited by guarantee with share capital. Okay, so they had no power to buy their own shares unless buyback happens. And very important, this section is not applicable to Nidhi company. In examination, chance is there they will explain a story of Nidhi company and they will ask whether Nidhi company can buy its shares or not. Answer, they can buy their share, they can buy their own shares. And second subsection, no public company either directly or indirectly finance anyone to purchase or subscribe its securities or its holding company's securities. Contravention, this is the punishment. Next one, but to this general rule, finance option not available. To this general rule, three exceptions are there. One is banking company, in the ordinary course of business they can lend the money. And next one, employees, loan to employee, that employee should not be KMP, that employee should not be director, and maximum finance will be 6 months salary. Maximum finance is 6 months salary, and the shares to be subscribed or to be purchased by the employee should be fully paid up. If these three conditions are satisfied, again exempted, so punishment will not come. Next one, scheme, listed companies follow SEBI, stock exchange related, SEBI follow SEBI. Unlisted companies, just wait, this is not a criteria at all. Here it is not a criteria, just I'm removing these two words. Fine. So yes, for a scheme, obtain a special resolution, and maximum financing of this scheme is up to 5% of paid up share capital and free reserves. Up to 5% only, that is a maximum finance. And with this amount under this scheme, the trustee should acquire fully paid up shares only. The trust is for the benefit of employees only. The trust is for the benefit of employees only. And here the employees will not be given voting rights under the scheme. Just make disclosures in the reports. And the entire this section is not applicable to IFSC companies, private companies, provided no other body corporate is a member in this private company. Total borrowings from banks, financial institutions and other body corporates, it is 2 times of the paid up share capital or 50 crores, whichever is less. And there should be no subsisting default in repayment of the above borrowings. If these three conditions are satisfied, then that private company can proceed with then that private company, for that private company section 67 is not applicable. Next, 68, powers of company to purchase its own security, simply buyback. For making buyback, the available resources are free reserves, securities premium, issue proceeds. But remember, shares in the buyback and issue proceeds should not be same. Different classes of shares should be there. Conditions for buyback, check AOA authorization. Coming to the resolution, amount required for buyback, if it is up to 10% of paid up share capital, free reserves, securities premium, board resolution is enough. Beyond 10%, but maximum 25% of capital, free reserves, securities premium, special resolution is required. Even with this also, maximum I can make buyback of 25% of paid up share capital only. See, this is count of shares, this is amount required for buyback amount. Post buyback debt equity ratio should be 2:1 and the shares should be fully paid up. Follow SEBI norms if you are a listed company. And from the date of board resolution or special resolution, buyback should be completed within 1 year or else pass one more resolution. Notice of meeting, along with that Q explanatory statement. In explanatory statement, disclosure of material facts, necessity for buyback, class of shares involved in buyback, amount required for buyback, and what is the time limit for completion of buyback. Everything should be disclosed. So buyback, you had 3 options. Either you can make buyback from existing members on proportionate basis, or you can make buyback from open market, or you can take back the securities which were given to the employees under ESOP or sweat equity. Next one, Company before making buyback shall file a declaration of solvency with ROC, and if a company is a SEBI listed company, with SEBI also. This declaration of solvency should be signed by 2 directors, one should be MD. And this declaration is all about, we will not become insolvent in the next 12 months. Even if company gets liquidated, our assets are in sufficient position to discharge liabilities. So like that, they need to prepare a declaration supported by affidavit, file it with ROC and SEBI if you are a listed company, or else ROC enough. Next one, time limits for buyback ma. Important time limits ma. Once letter of offer filed with ROC, now send that letter of offer to the members within 20 days of ROC filing. Today I filed a copy with ROC. Immediately within 20 days, give that letter of offer to the members. And offer period, buyback offer period, minimum 15 days, maximum 30 days. So during this offer period, interested candidates will surrender their shares, company will pay money to them. And once offer period is over, company to verify the offers, to verify the share certificates, to verify the applications, for company 15 days time was given. Once 15 days is over, within next 7 days, company should complete payment, or at least company should communicate rejection. Your application has been rejected. Like that, they need to communicate rejection. They need to communicate the rejection. For that, the time limit is 21 days of closure of offer. 21 days of closure of offer. Next one. Suppose buyback completed. Now within 7 days after completion of buyback, destroy the securities. Cooling period. Once buyback is completed, rights issue of same class not allowed, bonus shares allowed, conversions allowed, sweat equity ESOPs also allowed, but rights issue, further issue of shares not allowed. Maintain register of buyback in format SH10 to be certified by or authenticated by CS or authorized person. So in that register you can see shares so bought back, cancellation of the shares, details of cancellation, consideration paid, extinguishment and all other particulars. Finally, after completion of buyback, it is the duty of company to file return of buyback SH11 within 30 days of completion of buyback with ROC, and if a company is a listed company, then with SEBI also. Next one ma, penalty for default, company minimum 1 lakh, officer in default minimum 1 lakh and maximum 3 lakhs. And if you have utilized company profits for making buyback, then the amount you utilize for buyback of equity share, the nominal value of the share which you bought back, that nominal value, transfer it to CRR. Nominal value to be transferred to CRR. CRR shall be utilized only for issuing fully paid up bonus shares. Next one, prohibition of buyback. In the following cases, buyback is prohibited. Which cases? Non-compliance of 92, 123, 127, 129. Non-repayment of deposits, interest on deposits, debentures, preferential capital, term loan, interest on term loans, banks, financial institutions term loans, non-payment of dividends. So if you had these kind of defaults, rectify them. After rectification, wait for 3 years. The next 3 years also, if you are not committing the same default, then you can proceed with buyback. With that, 70 also over. Coming to the last section, debenture. This is a big chapter, but because of handwritten notes, I'm able to reduce the time. So in this way, you need to revise a day before examination. Chalo, debenture. Debenture includes debenture stock, bonds, instrument, any instrument evidencing a debt. But debenture excludes instruments already notified by Reserve Bank of India, Government of India in consultation with RBI. So simply chapter 3D instruments, the instruments which were notified in chapter 3D, even though they are evidencing debt to the company, so that is not treated as a debenture. Just wait, yeah. That is not treated as a debenture. Next one, manner of issue of debentures. For convertible debentures, take special resolution. Non-convertible, within the limit, section 180 subsection 1 clause C, board resolution is enough. Beyond the limit, special resolution is required. Debentures shall not carry voting rights. For secured debentures, the following conditions are applicable. Maximum redemption period, maximum tenure is 10 years. For infra companies, maximum tenure is 30 years. And for secured debentures, you need to appoint trustee. The charge can be created on company assets or holding company assets or subsidiary company assets or associate company assets. The charge will be registered in favor of trustee. Market value of charged assets shall cover both principal amount of debentures, also interest on debentures. Next one, trust deed shall be executed within 60 days of allotment. Debenture redemption reserve, non-convertible portion. For non-convertible portion, debenture redemption reserve is not applicable. For unlisted companies, the two other than banks, financial institutions, all India financial institutions, so debenture redemption reserve is applicable. Just wait a minute. So this is my original handwritten notes. You have seen it previously also. So this one I compiled into the latest handwritten notes book. So for debenture redemption reserve, let me show you in my handwritten notes itself. So debenture redemption reserve is applicable only for non-convertible portion, because for convertible portion, previously I told for non-convertible portion. No. Listen, for convertible portion, DRR is not required. Only for non-convertible portion. Here we need to pay in cash. We need to settle in cash. So that's why there DRR is compulsory. And for unlisted companies other than banks and financial institutions also, DRR is applicable. How much? Just 10%. Coming to the investments into the liquid assets, it is of 15% for the debentures maturing in the financial year. For the current financial year, what are all the debentures are getting matured? So on or before 30th April, transfer the funds to liquid assets. For listed companies, publicly placed, for listed company other than financial institutions, other than banking companies, only for publicly placed debentures create investments. Unlisted companies, both publicly placed, privately placed, for both investments in liquid assets is compulsory. And DRR shall be created out of divisible profits used for redemption of debentures. Useful for repayment of dividends. DRR shall be created out of divisible profits used for redemption of debentures. Now let's see. Appointment of trustee. Whenever an offer was given to the public, or if the number of members exceeding 500, we are offering debentures to the existing members. If members are more than 500, then appointment of trustee is compulsory. For that, prior written consent and disclosure of the trustee details also important. So you need to take written consent from the proposed trustee. So before naming that fellow as trustee, you have to take prior written consent and disclose the same in the prospectus or private placement documents. Disqualification. With these disqualification, person cannot act as a trustee. If he is a beneficial holder of the shares, disqualified. Promoter, director, KMP, officer, employee of cash. Cash means company, associate, subsidiary, holding. So 4 companies, 5 persons disqualified. Even relatives of our company, promoters, director, KMP also disqualified. Creditor disqualified, but debtor 5 companies, our company, associate, subsidiary, holding, subsidiary to holding, fellow subsidiary, disqualified. Surety also disqualified. Material pecuniary relationship during the 2 financial years, preceding financial years or current financial year. Again disqualified. So remember these disqualifications. For removal of trustee, 3/4 value holders consent is required, and for filling the vacancy, casual vacancy, board resolution enough. In case of resignation, board resolution plus majority of debenture holders support is required. So trustees shall take all the steps to protect the interest of debenture holders. Debenture trustee fails to exercise reasonable care and diligence, then he will get punishment. Even though any provision in the trust deed exempting him from the punishment, that provision in the trust deed becomes void. Of course, 75% of the debentures holders consent, 75% of the value of the debentures holders consent, 75% of the debentures value holders consent. If they give approval, then he will not get any punishment. Pay interest according to the terms, redeem debentures according to the terms. In case of anticipatory breach, trustee will approach NCLT and will request to pass an order. Will request NCLT to pass an order. So like imposing restrictions on future borrowings. In case of actual breach, trustee or either debenture holder can go to NCLT. NCLT will order for specific performance. That means pay immediately. Next one, specific performance. That's what I told you. Powers of CG, procedure for securing debentures, form of trust deed, inspection copies, DRR, quantum, and others. So all these central government may prescribe from time to time. At last, you can see sections chart of share capital and debentures. So with this, I conclude marathon of share capital and debentures. So today's agenda we finished. Small corrections are there. So it will take me another 1 or 2 hours to rectify these things. Once rectified, I'll upload the same in Google Drive and I'll share the link. Don't worry. So this is a free resource only. No need to pay a single rupee also. At last, once again I'm telling you, this is not a substitute to the class lectures. Why I'm telling you, the reason is, listening to this, don't think that, sir, enough for examination, is this enough? Because I'm looking at the comments. Looking at the comments, I'm telling you. So just going through this marathon, is it enough for scoring exemption? If anyone tell you, yes, enough, don't trust. Including me also. Including me. Don't trust. Just by watching marathon lectures, scoring 50, 60, so scoring 60 is not a true It's not a true statement. So these marathons are just meant for revisions. Again I'm telling you, sir, we are facing a problem with revisions. If you look at the book size, sir, concept book 250 pages, question bank some 300 pages, total 550 pages, sir. So we are facing a problem in revising this 550 pages document. For you, the solution is marathon. That's it. Okay. So the link, Google Drive link, the new link I'll share with you. Don't worry. And tomorrow the class timing is normal 6 to 9. Of course, I will let you know. I'll let you know. But 3 hours we will have it. We will have a 3 hours marathon, 6 to 9 only. Whether it is 6:30 or 5:30, I'll share you the link also. Clear? So that's it for today. See you tomorrow. Take care. Tata. Bye bye.